Item 27, that matter. Mr. Dhar is still in the thing, water logging.
Oh.
So let it be tomorrow. Tomorrow, I may be permitted to mention so that it's been taken away to. Otherwise, he has also submitted in the case. Let it be.
Okay, can we make it day after tomorrow?
There,
Because then tomorrow is a motion day.
yes, day after tomorrow. I may be permitted to mention so that it may matter can be taken.
Yes.
Because I have completed my submission.
Correct.
He has also completed his.
This item number
27.
21, list on 6/6/2024.
At 2 p.m. if it is possible.
I don't want to write it to them. You can ask your assistant counsel to make a mention. On the ground that the learned additional senior government advocate could not reach the court on the matter stands adjourned today. Next one. Liberty is granted to the senior counsel, to Mr. Bididas, learned senior counsel for the petitioner, or is instructing counsel to make a mention for updating the matter.
May please, Your Lordship.
Yes.
And with the consent of the other side, I beg to mention item number 20, my lord, on behalf of Mr. B. Burman, my lord.
This is two friends don't want to sit together. Mr. Das. Two friends don't want to sit together. Two old friends don't want to sit together. He'll become different.
He knows me more better than I know myself.
It's okay. We've seen both of you together after a long time. So,
He had some dispute yesterday. I said the judge should be his son. He said, I'm not going to accept his judgment.
Because
Item 21, not 20.
that should be qualified to settle our disputes.
yes, we have some lighter times. Mr. Bhargava.
He was compelling me to accept the judgment of my son. I said, Nasimullah, I'm the last one to accept success.
You throw that here, I will give that judgment.
My lord, he raised the dispute, I didn't.
Yes, Mr. Bhargava, some lighter moments.
Well, item number 20, my lord. I'm making a mention on behalf of Mr. B. Burman, my lord,
Yes.
who is appearing for respondent number 1, 2, and 3. Let the matter come after 2 weeks, my lord.
You have taken consent of Mr. Viswas?
Well, he has taken consent, my lord.
On behalf of the private respondents,
Number 1, 2, and 3, my lord.
on behalf of respondent numbers 1, 2, and 3, here for adjournment has been made by Mr. Bhargava and counsel, which is made with the consent of the other side. Next, matter stands adjourned today, list after 2 weeks.
Much of it.
May I please, Lord? Lord, with the consent of other side, my lord, item 3, my lord. Kindly be taken next week, my lord. My answer is out of station today, my lord.
The date may be fixed, lordship. Can it be on?
Item 3.
Okay, next we give a date, list on so and so, as paid for by learned counsel for the respondent. Mr. B. Rahman, counsel for the respondent.
Right. 12, yes. Silent.
May it please your lordship. Lordship, I beg to mention item 6, lordship. Let's let it be taken a day after tomorrow, lordship. 6.
6. Not after, we make it on Friday,
Friday, lordship, some difficulty, other out of station case. Then the next week,
10th.
10.
Mr. 10/6/2024, as paid for by Ms. T. Som, counsel for the petitioner.
Obliged, lordship. May this lordship, I beg to mention for listing of a new petition tomorrow.
Give it to the court master.
May I please, lordship, I beg to mention item number 18, my lord. My lord, matter may be taken up next week, my lord. My senior is out of station, my lord, today.
18.
1.
List after a week, as paid for by learned counsel for the petitioner. Okay.
This item number 8 and 9, unfortunately, I have not been able to get consent because I have not been able to meet the counsel for the petitioner, your lordship. On the last
8
two,
is 8 is
8 and
again-
9, your lord.
It is 2014 matter. We are not inclined to adjourn it now.
Lordship, what has happened is that Mr. J.K. Goswami was supposed to go through the record. The records are very voluminous. Your Lordship will kindly see. Today, Your Lordship, it will not be possible for me to go through the records and do it. That's why Mr. J.K. Goswami was supposed to, but today he is not present here. That's why I'm saying that.
You
Otherwise,
see-
Your Lordship, let the matter come. Otherwise,
Can I look at the record and show you what is to be seen here?
Yes, Your Lordship.
Because this entire records are not necessary. We need only the particular record with regard to that the issue involved.
Lordship. Anyway, Your Lordship, I have not been able to meet with the petitioner, so
Okay.
let the matter come, Your Lordship.
You all are experienced persons in looking at the records. You don't want, if you want, you won't spend much time.
Lordship.
Yes, item 1.
Lordship, I appear for private respondent number 7 to 28, Your Lordship. And Mr. K. Chaudhary appears in this matter, Your Lordship. And due to some difficulty, today he's out of station.
If Mr. Chaudhary sees the video, he will not be happy. He has gone for professional work. It can be difficulty. Okay, okay. Both sides are represented on the prayer made by Learned Counsel for the private respondents. Number 7 to 28, the matter is adjourned today. List after a week.
My lord, can it be on 18th of June?
Okay, 18/6.
Deeply obliged, Your Lordship.
Oblige, Your Lordship.
Item 2.
Yeah, please, Your Lordship. Lordship, here the matter, the Lordship selects appointment of assistant teacher, Lordship. Assistant professor.
Just one minute. Who's appearing for the respondent?
I'm the correspondent of this one.
You have the disability certificate.
Health department will produce the record. Also, health department already filed their affidavit.
They have produced your
They filed their affidavit.
medical disability.
Lordship, in their affidavit, they have admitted that her disability is progressing, Lordship. She has a benchmark disability with 40% disability, Lordship. And the medical board held that she has only 13% disability. Later on in AIMS, Lordship, it was stated that she has more than 80% disability. Now, Lordship, the superintendent of GMCH has filed this affidavit to the effect that it is likely that the petitioner has progressive hearing loss. They have admitted it.
Please, Your Lordship.
Your disability would not be very high.
Lordship,
You have a
as per my
hearing
disability,
impairment since birth.
Lordship, she has a specified disability with 40% disability, Lordship, and annexure A of our petition. There's a page 24, Annex A, Lordship.
Just one. Yes, you have the medical.
Lordship
Report.
here, Lordship, the principal has filed his affidavit on 28/2/24, Lordship. Here, the first test was reassessment was done on 22/9/2022, where it was found that she was having 13%, Lordship, hearing disability, Lordship. Then, Lordship, after around 6 months, Lordship,
13, it should be more than 13% because the threshold, see page 104,
yes, Lordship.
104. You've seen that
Yes, Lordship.
threshold decibel is 95 and 90.
Yes, Lordship.
This is on higher side because 0 to 80 is normal.
But Lordship, then later on, after 9 months, on 8/6/2023, she was again re-examined.
Which page?
Page 134 of our affidavit, Lordship. Page 134 of our affidavit. On 8/6/23, Lordship, after around 9 months, she was again reassessed, Lordship. This was of 8/6 to, but the affidavit is quite silent about the percentage of that was found on that day, Lordship. So, Lordship, this is purely technical, Lordship. So I want to file a short affidavit just to bring on record that what was the percentage of disability that was found on 8/6/2023.
Lordship, Ames report is there, Lordship.
Lordship, Ames report,
Ames report is there, Lordship.
The medical college is looking at it.
yes, Lordship.
Lordship, Medical College,
And already we have done her second reassessment on 8/6, Lordship.
it is not reassessment, Lordship. It is personally she approved, Lordship, for treatment, she, Lordship, approves the GMCH.
For re-verification,
And
It's
also
not-
there is no provision of reassessment of permanent disability, Lordship, as per the Disability Act 2016.
But
you,
that
you, have
OM,
seen-
Lordship,
you have seen what has happened. How correct are those reports?
yes. And
This is Lordship Ames report. Lordship,
Ames report,
Which
And-
page?
Lordship,
Lordship, page 128, Lordship. Lordship, see on her own, Lordship went to the Ames, Lordship, New Delhi.
not her own Lordship, the medical board, district medical board have referred her for higher medical Lordship opinion.
Lordship, for us, higher medical opinion is DME, Lordship, higher authority means DME, Lordship.
128.
Yes, Lordship.
I have annexed this Ames report, Lordship, in our additional affidavit.
Lordship, that 104, Lordship has own, Lordship.
One zero three.
Here also, they are not giving percentage.
No, Lordship, that is the main issue, Lordship. That's why, Lordship, on 8/6, which was done, Lordship, 23, I want to get the instruction, what was the percentage?
Better.
Yes, Lordship, because these are technical, Lordship.
Lordship,
103 does not say percentage.
percentage, but it says that 93.33 dB and 88.33 dB. And as per the specified schedule, Lordship, schedule of the Act 2016, page 46, Lordship, page 46.
Disabilities Act. Right.
2016 percent with benchmark.
Page 46, it relates to specified disability, Lordship. Relevant is page 47. Page 47, Lordship C, hearing empowerment. Lordship, deaf means persons having 70 dB hearing loss in speech frequencies in both ears. Hard of hearing means person having 60 dB to 70 dB hearing loss in speech frequencies in both ears. Here, Lordship, as far as AIMS report, her right ear, Lordship, 93.33 dB. And in the left ear, 88.33 dB.
No, let the medical college give it. Let us have it.
They are not, Lordship.
For this, they will run counsel for the petitioner. That's all. Mr. D. Upamanyu, Leonard, standing counsel for the health department, has submitted that as the issue regarding hearing impairment of the petitioner is a technical issue. Base for is granted, divided to file. The health department of the state of Assam is including the Guwahati Medical College and Hospital is permitted to file an affidavit. So inform the court about the nature and extent of disability of the petitioner regarding hearing impairment. Next, in this regard, the learned counsel for the petitioner has referred to the schedule of the Rights of Persons with Disabilities Act, 2016. And by referring to clause C thereof, it is submitted that the same prescribes the degree of hearing impairment. Next, accordingly, the person swearing the affidavit on behalf of the health department of the state and or on behalf of the GMCH shall take into consideration the nature of disability specified in the schedule appended to the Rights of Persons with Disabilities Act, 2016. List on, listed after 10 days.
That may be fixed, Lordship.
But can it be after 2 weeks, Lordship? 2 weeks, Lordship.
Suggest a date.
Oh, wait, okay.
Any date, Lordship, as per
19/6/2024.
Lordship. Oh, bless you.
Item 4
Helio.
with 5.
Yes.
May I please, your lordship? My lord, the matter relates to, my lord, promotion of the, for the depriving the petitioner from her promotional avenue from the post of Anganwadi helper to Anganwadi worker. My lord, there is a provision has been made by way of a notification dated 4/3/2013, my lord. My lord, may be pleased to find that notification is at page 22 of my first writ petition, my lord, 4619 of 2022, my lord. Page 22, annexure 2, my lord. Lord, this is a notification dated 4th of March 2013. My lord, this notification is relevant part is at, my lord, under the guidelines, clause 2, my lord. Only those Anganwadi helpers shall be eligible for promotion under this scheme who have been in continuous service for a period for 10 years and above as Anganwadi helpers in any duly sanctioned Anganwadi centers, my lord. The qualification criteria, my lord, is at page 23. To have passed the class 9 examination from school oblique madrasas duly recognized by the Board of Secondary Education Assam.
But in this,
My lord.
you are paying for the government. In this, there are several judgments where the government has been directed to consider and if the Anganwadi helper is entitled to be considered for promotion, then you have to give it.
The educational qualification question remains your lordship, whether she is at all for class 9.
No, we will presume that he has it because otherwise the petitioner would not have been here. You would have given a preliminary objection.
Lordship will see our affidavit in the other next.
You're not qualified.
Lord, they have taken a stand that I have not qualified. I have demonstrated the certificate. Even, my lord, the Board of Secondary Education registration is also there for appearing in the SSLC examination as I have passed out the class 9. Those certificates and the, my lord, documents has been discarded, my lord. And they have said that I have exhibited a certificate from in school, which is not in existence, my lord, which in fact is not correct, my lord. My lord, I have also annexed the SSLC admit card at page 44, annexure 11 to my first writ petition, my lord.
Page?
Page 44, annexure 11, my lord. This is the, my lord, high school living certificate examination of 2018, but I could not pass out the SSLC examination, my lord. But that means, my lord, this document demonstrate, my lord, that I have passed the class 9. That's why this certificate, this document had been issued. School's name has also been shown, my lord, as Chandmama High School. And this is my, my lord, document which can be relied on, my lord, by the authorities also. They can verify, my lord, that whether this I have done my studies in Chandmama or not.
Once you have this page 43,
Mile.
it is from a different school. You can't be a student of
No, my lord,
another
yes, yes.
school.
Yes, my lord, that is the, that clarification we have stated, my lord, that this, my lord, from this Paschim Kazersor, my lord, I have transferred and take admission in, my lord, Chandmama High School, my lord. That's why, my lord, from Chandmama, I did, my lord, applied for the registration under the SEBA for appearing in the SSLC examination, my lord. Because, my lord, when the authorities registered, my lord, they are required to verify the document, certificate and everything, that whether, my lord, I am pursuing the course at Chandmama or not, my lord.
Where is any other supporting document of this school?
My lord, the Mama certificate is an super. Next one. Okay. Lord, in my second writ petition, my lord, an speaking order had been passed by the Director of Social Welfare, my lord, on 27th of January 2020. My lord, may be pleased to peruse the same, my lord. No certificate, my lord. My lord, practically available. Next full is no.
No, this something is so fraudulent. We'll have to ask for an inquiry. This can't happen.
Lord, even the
You,
Board of
you
Sec-
see,
my
you
lord,
see, you are showing us page 43.
my lord,
In 43, says that this is a certificate of 4/2/2002.
my lord.
It says that she is reading in class 9 and had passed examination for promotion to class 10.
No, my lord, in
I
Kochim
don't know.
Tatersar High School, my lord. Yes, my lord.
Correct. So after 10, you go to class 9.
My lord.
You must be the one of the brilliant students.
No, my lord. She was reading in class 9 and had passed the examination for promotion to class 10.
After that, you take admission in class 9.
My lord.
You should be very brilliant.
No, then again, my lord, I took admission in, my lord, in Chandmama High School,
In class 9.
class 9, my lord.
Very good. And you want us to believe it.
Then, my lord, I have also appeared in the Board of, my lord, this is a certificate issued by the Board of Secondary Education,
I don't understand.
my lord.
Except for this, now I'm saying brilliant, not for any sarcastic reason.
My lord.
But now we find that people who are doing medical, who are going for engineering, they think that they got that 90% and is too low. Therefore, they want 94, 95, and therefore they drop out.
Demoted, my lord.
They wait for a year, again give an examination, come out brilliantly and go to a better institution. So I know few people who are in that category, getting more than 90% and then opting out for 2% more.
But my lord,
After the foundation is strong, made strong, Yes, page 40.
Page 40, last paragraph, my lord. Whereas the CDPO, my lord. Whereas the CDPO Rupshi in her report received by letter number so and so dated so and so has stated that though the eligibility for the post of AWW is mentioned as class 9 pass as per government notification dated so and so, Srimati Jahanara Ahmed, petitioner, my lord, submitted an application with class 8 pass certificate during selection, and office received her class 9 pass certificate only on 10/8/2017. The petitioner also submitted two different certificates dated 26/7/2001 issued by the principal Paradhara Higher Secondary School, Larukusi, Nolbari, with the writ petition, and another certificate dated 4/2/2002, that certificate, 9 pass certificate, issued by the headmaster, Puchim Kajeshwar High School, Larukusi, Nolbari. But on due verification by the CDPO, Rupshi ICDS project regarding class 9 pass certificate issued by the headmaster Puchim Kajeshwar High School dated so and so against Jahanara Begum, it has been found that the concerned headmaster of Puchim Kajeshwar High School denied of issuing any such certificate. The same can be evident from the declaration submitted by Jinod Ali Ahmed, the former headmaster and issuing authority of the class 9 pass certificate of Jahanara Ahmed, as well as the present headmaster of Puchim Kajeshwar High School. He read class 9 in 3 different schools, my lord. Page 42 is from different school. That is where she failed in class 9. Page 43, my lord, that is found to be fake. And on the basis of page 43 certificate, she appeared SSLC examination from another school, my lord, not from that school, my lord. And thereafter, after issuing this order, my lord, advertisement was made. I have, my lord, participated in the selection process along with other candidates, and I have been
This, selected and appointed, my lord. WPC 5761 of 17. In this WPC 7561 of 17, what is the issue involved? Are you aware,
My
Mr.
lord,
Bhuyan?
yes, my lord, because I have of lately, my lord, has been.
Then I will tell you what has happened if you don't know about it.
My lord,
Come to page 44. The story is affluent.
my lord,
Now, page 44,
my lord.
you look, this certificate refers to the examination to be held
Correct.
in February 2018,
18, my lord.
correct?
Correct, my lord.
Now, this does not have the date of your admission,
That is correct, my lord.
correct?
It is
Now,
after this process, my lord.
that's okay,
My lord.
but this is, once this is once they give a tentative date of commencement of the examination,
My
it is sometime in the last part of 2017, has to be.
my lord.
Now, your petition was filed in 2017. That means thereafter you got yourself this certificate
Admitted in Chan Mama, my lord.
in this school,
My lord. My lord.
just to create a document for your writ petition.
Mm,
In 1997, you passed class 9. There's no reason for you to wait for 9 years and get admitted in class 9 again.
my lord.
This 9 is
9 years, not 19 years, my lord. 2018, and 97, my lord.
no. The earlier certificate fees is paid up to 1/1/97.
Yes,
So that means 97, now it is 2018.
yes, my lord.
It's 9 years.
No, my lord. About 20, I think 21 years, my lord.
21 years.
97 and 2018, my lord. 21 years, my lord.
No,
Or 21 years.
Yes, my lord.
My lord.
97, 21 years.
21 years.
So after 21 years, you wait and you get it yourself admitted in class
9 again.
9.
My lord, I have stated in paragraph 14 and.
No,
15.
this can't be, because this admission is only for the purpose of this. We dismiss your petition.
My lord.
And that
You
post
can't.
already filled up, my lord, by way of advertisement. Advertisement was made and we have participated, my lord, and I have been selected for the said post.
My lord, in paragraph 14 and 15, at page 12 and 13, my lord. But my lord, one thing is there that, my lord, I have in Chandmama, my lord. There is no dispute that I have admitted in Chandmama and tried to, my lord, appear in the SSLC examination from Chandmama High School, my lord. That means, my lord, my lord, of late, I have passed class 9 examination, my lord. Lord, there is another aspect is there, my lord. If somebody is also past class 9, Lord, if he is required to fill up the form for registration, my lord, he cannot directly go to class 10 and can apply for the registration, my lord. That is the instruction I have received, my lord. That is the SEBA regulation, my lord. That's why, my lord, perhaps this class 9 again admission she has taken in Chandmama, my lord.
Yes, for the government, what do you have to say?
Item number 4, your lordship, where we have taken a categorical statement in WPC number 5453, where we have categorically taken a stand in para 6, your lordship, page number 21. Regarding the class 9 pass certificate being obtained fraudulently by the petitioner, your lordship. Now, they have not filed a rejoinder affidavit so far as my knowledge goes, your lordship. So at the very least, this aspect they needed to counter, if nothing else, your lordship.
It's not fraudulent, my lord. Fraudulent.
No, we have taken a stand. They needed to counter that. That's what. I can read it, your lordship, if your lordship.
It's okay. Mr. E.R. Bunyad and the counsel for the petitioner. The two petitions together. The also heard Mr.
C.S. Hazarika.
C.S. Hazarika, the government advocate appearing for respondent number.
Lots of state respondents because there are two separate cases.
For state respondent, numbers 1 to 4.
Yes, in both cases, 1 to 4.
1 to 4. And Mr. H.R. Ahmed, learned counsel for respondent number 5. Next one. In brief, the case of the petitioner is that she is working as Anganwadi helper at 105 Mohia, MOHIA, Anganwadi Center since the year 2002. Stop. In the year 2016, the post of Anganwadi worker of the same Anganwadi Center fell vacant. Full stop. The In terms of the notification dated 4/3/2013 issued by the Social Welfare Department, Government of Assam, the petitioner claims that she's she's otherwise eligible to be considered for promotion and obligor to be upgraded to the post of Anganwadi worker. Full stop. However, as the respondent number 5 was transferred and appointed to the post of Anganwadi worker at the said 105 Mohia Anganwadi Center, the petitioner has approached this court by filing a writ petition, and in her said writ petition, this court, by an order dated 27/3/2019, passed in WPC 7561 of 2017, had directed the Director, Social Welfare Department, within bracket respondent number 2, to consider the claim of the petitioner. Next paragraph. The Director, Social Welfare Department, pursuant to the order of this court, directed the CDPO is Child Development Project Officer.
Yes.
Child Development Project Officer within bracket CDPO, Rupsi, to cancel the transfer order dated 8/7/2016 and to take necessary steps for upgradation of Anganwadi worker from Anganwadi worker from Anganwadi helper in the said Anganwadi center as per the government rules. Accordingly, the transfer order till 8/7/2016 was cancelled. This transfer order was of respondent number 5, Mr. Ahmed, or some other person. I said respondent number 5. Huh? I said respondent number 5. Strike out this. It is not respondent number 5. Huh? You should strike that respondent number 5. Then continue.
No. Abida Ahmed, your lordship. Lordship will see the order dated here 27/22 here it is reflected. However, CDPO Ruposi ICDS project Borpeta transferred one Srimati Abida Ahmed, Anganwadi worker.
Abida Ahmed. Full stop. Accordingly, the CDPO, comma, Rupsi within bracket respondent number 4 issued an advertisement dated 21/12/2017, comma, seeking applications from eligible Anganwadi helpers for filling up the vacant post of Anganwadi worker under Mohia, MOHIA, Revenue Village. Next paragraph. The petitioner approached this court again, and this court by order dated 5/2/2018 passed in IS Civil 135 of 2018 in connection with WPC 7561 of 2017. State the operation of the advertisement dated 21/12/2017 and granted liberty to the respondent authorities to upgrade the petitioner as Anganwadi worker in terms of letter dated 27/7/2017, comma, issued by the Director of Social Welfare. Full stop. Next paragraph. Thereafter, the CDPO, comma, Rupsi. What is the correct spelling of Rupsi? RUPSHI or RUPASHI?
SSCSHI.
RUPSHI.
SHI.
Okay. Because in your cost title of the writ petition, you are spelling it as RUPSHI.
It's a typing mistake.
No, it's
It
okay.
should be RUPSHI, you know.
The respondent number 4 in a report white letter dated 18/2019 pointed out that the eligibility for the post of Anganwadi worker is class 9 as per the government notification dated 4/3/2013, comma, however, comma, the petitioner had submitted an application with class 8 certificate, and during selection she produced a class 9 certificate on 10/8/2017. Full stop. It was reported that the petitioner had also submitted 2 different certificates dated 26/7/2001 issued by the principal, comma, PERA DHARA Higher Secondary School, comma, Laru Kusi LARUKUCHI, comma, Nalbari, within bracket annexed to the writ petition, bracket closed, and another certificate dated 4/2/2002, comma, issued by the headmaster, comma, Paschim Kaziswar KAZESWAR High School, comma, Laru Kusi, comma, Nalbari. Full stop. Upon verification by the respondent number 4, comma, the headmaster of Paschim Kaziswar High School had denied issuing certificate dated 4/2/2002 to the petitioner. And in this regard, the respondent number 4 relied on a declaration given by one former headmaster and the issuing authority of class 9 pass certificate of the petitioner, as well as the then headmaster of the said school. And accordingly, he had arrived at the conclusion that the petitioner lacks the requisite eligibility qualification to hold the post of Anganwadi worker as per notification dated 4/3/2013. Next, they said order is under challenge in WPC 4619 of 2022. It is also projected in this petition that the respondent number 5 has been appointed to the post of Anganwadi worker, whose appointment is also assailed in this petition. Next one. Next one. The petition had subsequently filed WPC 5453 of 2023 to challenge the appointment order dated 29/3/2022 in respect of the upgradation of the respondent number 5 as a Anganwadi worker for voluntary service at 105 number Muhia, MUHIA, within bracket A, bracket goes Anganwadi Center, from Anganwadi work helper. Next paragraph. The learned counsel for the petitioner, by referring to the stand taken in the affidavit in opposition, in the writ petition, has submitted that the petitioner resides in a remote village and therefore, notwithstanding that the petitioner had passed class 9 in Paschim, PASCHIM, Kaziswar, KZESWAR High School, as per certificate dated 4/2/2002, in the year 1996-7, but she had to be readmitted in class 9. Subsequently, in Chandmama, CHAND, MAMA High School, First of all, that's why it is also submitted that the petitioner had, in a short span of time, had been transferred from two schools. Which itself is not a ground to question the educational qualification of the petitioner. First of all, it is also submitted that the present certificate on which the petitioner is relying is issued by the Board of Secondary Education Assam in respect of High School Living Certificate Examination, 2018, which discloses that the petitioner is registered as a student of Chandmama High School and that the said certificate is valid for HSLC examination, 2018, which was due to commence from 16 to 2018. Accordingly, it is submitted that the said document is a conclusive proof that the petitioner was a student of class 9 and therefore eligible to be upgraded to the post of Anganwadi worker from the post of Anganwadi helper. Next para. The learned government advocate as well as the learned counsel for respondent number 5 while referring to the stand taken in the affidavit in opposition has submitted that the have submitted that the respondent number 4 after due inquiry arrived at the conclusion that the class 9 certificate dated 4/2/2002 not being issued by the concerned headmaster of Paschim Kaziswar High School was a fake document. So it was also submitted that the statement made in the affidavit in opposition filed by the state respondents has not been specifically denied by the petitioner. This slide is also submitted that the respondent number 5, in the meanwhile, had joined her new place of posting and in this regard, reliance is placed on the joining report dated 1/4/2022. Next para. On a perusal of the order dated 27/1/2020, impugned in the in WPC 4619 of 2022. It appears that the petitioner along with her application had submitted a class 8 certificate during her selection as this page 40, what do you intend to say? Page 40. The petitioner also, the class 8 certificate during the selection. Selection as what? As Anganwadi helper. And that the office of respondent number 5 had received her class 9 pass certificate only on 10/8/2017. Full stop. The respondent number 4 also held that the petitioner had submitted 2 different certificates. One dated 26/7/2001, issued by the principal, Peradhara, PERA, DHERA, Higher Secondary School, Larukusi, LARU, KUCHI, Nalbari, which was enclosed to the writ petition. And there's another certificate dated 4/2/2002, issued by the headmaster, Paschim Kaziswar, KZES WR High School, Larukusi, Nalbari. Next one. As per certificate issued by the Peradhara Higher Secondary School, the which is a transfer certificate dated 26/7/2001, the petitioner had left the school on 31/12/1995, and she was reading in class 9. And had not passed the examination for promotion to class 10. So, as per the contents of the certificate issued by Paschim Kaziswar High School, the petitioner had left the school on 31/12/1996, and she was reading in class 9 and had passed her examination for promotion to class 10. Full stop. Having passed class 10 in the year 1996, the document annexed to the writ petition, which is a Board of Secondary Education, which is a certificate issued by the Board of Secondary Education Assam in respect of high school leaving certificate examination 2018. Where the petition is registered for appearing in the HSLC examination 2018 to be held from 16/2/2018. XPC appears to be a document which is created for the purpose of an evidence in this writ petition. First of all, there is no explanation as to why the petitioner having Yeah, having cleared her class 9 in as on 31/12/1995, could have herself admitted in class 9 again in a different school, which she left on 31/12/1996.
Now in para 14 and 15, we have explained, madam. Kindly be recorded. Madam, in fact, she also appeared in the SSLC but failed, madam. So mark sheet we have, madam.
Which one? Next paragraph. Next, we learn counsel for the petitioner is referred to the statement made by the petitioner in paragraph 13 and 14 of the rate petition.
14 and 15, madam.
So 14 and 15 of the
Mark,
rate petition
12 and 13.
disclosed reasons why the petitioner was again admitted in class 9 and that she could not clear the class why she could not continue her further studies after class after being promoted to class 10. Next paragraph. In this regard, as the respondent before is already verified and had arrived at the conclusion that the petitioner had not been issued a certificate dated 4/2/2002 by the then headmaster of Paschim Kaziswar High School. The court is disinclined to be sympathetic to the petitioner. Who is manufactured document for the purpose of her entry into service. Stop. The subsequent HSLC examination 2018 document having been held to have been prepared, only produce it as an evidence in the rate petition of the which was rate petition being WPC 7561 of 2000. As well as WPC 4619 of 2022. Though indicates the petitioner to be otherwise eligible, but her conduct of procuring a fake certificate from the concerned school disentitles the petitioner for a consideration to be upgraded to the post of Anganwadi worker at the cost of service of the respondent number 5. Full stop. Next para. Either as it may, comma, if the petitioner is this order shall not come in the way of the petitioner to produce all the relevant documents to the Director of Social Welfare Assam by demonstrating that she was a regular student of any school, comma, it would be open to the said authority to re-examine the educational documents of the petitioner vis-a-vis her explanation for the change in schools. And it would be open to the said authority to make a fresh inquiry and to consider the claim of the petitioner for her upgradation from Anganwadi helper to Anganwadi worker. Full stop. Next, in this regard, the court is inclined to grant 15 days time from the date of the order to produce all the testimonies before the CDPO from RFC, who on receipt of the same, within bracket respond number 4, who on receipt of the same shall forward the documents to the Director of Social Welfare Assam in bracket respond number 2 for consideration.
Regarding raised consideration in any other post, my lord, because that,
We are not saying anything. That is for the authorities to decide.
that
that is-
still up through selection process much.
That is for the authorities to decide where they want to post someone.
Lordship, the director, now it has been renamed as Director of Women and Child Development, your lordship. Social welfare,
You say within the bracket now renamed as Director of
Women and Child Development.
Women and Child Development from Assam. We are saying so because if she has a certificate, then she has to be considered, rightly or wrongly.
Yeah, but
Not in this case at the cost of so and so, but she has to be considered. One mistake will not ruin her career.
Item 7.
Wait, please, your lordship. Your lordship, this writ petition was filed, challenging the appointment of respondent number 5.
Yes,
Selection and appointment of respondent number 5. APSC conducted a selection process for filling up.
this is appointment under sports quota.
Yes, your lordship. Sports quota,
Just-
district sports officer.
Just a moment. Yes, what is your ground to, what is your ground to say that the certificates were fake or false certificate or false information?
Your lordship, when the respondent number 5 applied for diploma course in sports coaching and athlete, if your lordship sees your lordship may peruse page number 32 and 33.
Just a moment, I'll come back to you. Just a moment. Uh, who's appearing for the government? You are appearing, Mr. P.K. Barwa. Mr. Barwa, this, what is your stand in your affidavit in opposition with regard to the educational academic qualification?
This process has been led by the APSC Lordship. So we have taken the light and we have only stated that he is not qualified.
Okay.
Qualified.
Yes, then APSC, what do you say about that qualification?
Lordship, we have followed the advertisement, Lordship.
24 July 2007. Notification, where is that? This is page
Right.
19.
Yes.
This is your corrigendum. This is what should be there. Now, according to you, what was the document furnished by the petitioner?
Your Lordship.
I'll come back to you. That's all.
Page 20 is the corrigendum.
Page 19 is that corrigendum. It says it has to be a degree or
Lordship.
diploma in physical education from a recognized physical training institute or 3 years degree in so and so. Correct. The petitioner claims that
Lordship, it's a degree holder in arts, science, commerce from a recognized university with a bachelor degree or diploma in physical education, Lordship.
the petitioner is alleging that the person, other than the bachelor degrees of art, did not
Right.
possess any other qualification. That is what only
Lordship, the
perhaps is
contention
due.
of the petitioner is that the diploma that the respondent holds, she has obtained the diploma by entering into the course by submitting a false document, Lordship. The diploma has not been challenged.
Okay, then we hear you. Yes.
If your Lordship may peruse page 30,
Page 13,
30, 30.
30. Yes.
Serial number 7, your Lordship. This document was submitted during to obtain diploma course in sports coaching. So, your Lordship, at serial number 7, she has mentioned higher personal performance participation as All India Intervarsity Athletic Meet held at BIT Ranchi in December 1991, throwing events. So here, your Lordship, she has not participated in the event. She has only represented the university, which your Lordship may peruse at page 34. Your Lordship, got it?
Where is the advertisement?
Advertisement is at page 18, your lordship,
18.
17.
The degree,
In BP or diploma in NIS. From a recognized physical training institute, university, national.
the
Institute of
degree
Sports.
in BPE. What is BPE?
Bachelor of Physical Education.
Or diploma in NIS.
Your lordship, in corrigendum
Yes.
at page 19. A candidate must be a degree holder in arts, science, and commerce from a recognized university with a bachelor degree or diploma in physical education, BPA, from a recognized physical training institute, or 3 years degree in bachelor of physical education from a recognized physical training institute. Then this corrigendum was issued, which was also in compliance with the or service order, which is at page 133 of the affidavit filed by APSC. At page 137, the qualification is mentioned.
Yes, where is the qualification?
At page 137. This is as per the Assam Sports and Youth Welfare Recruitment and Promotion Service Order 2001. It's mentioned that graduate in arts, science, commerce from a recognized university with a bachelor degree or diploma in physical education from a recognized physical training institute. So your lordship, here the respondent is holding the diploma in sports coaching, which is at page 95, your lordship, of the affidavit filed by R5.
Okay.
She holds the diploma in sports coaching. So it is not as per the corrigendum, your lordship. Now, if your lordship will see the affidavit filed by the Director of Sports and Youth Welfare at page 40.
Page
40. Paragraph 5, your lordship. that with regard to the statements made in paragraph 17, 18, 22, 23, and 20 of the writ petition, the deponent begs to state that the respondent number 5 does not have requisite qualification as per Assam Sports and Youth Welfare Recruitment and Promotion Service Order 2001. Now, your lordship, if, your lordship, at page 53,
Yes.
this is the affidavit filed by the respondent number 5. She admits here that at 11 line, 11th line, but the deponent was selected at page 53, your lordship.
Continue.
But the deponent was selected to represent the Dibrugarh University in athletic team for All India Inter-Varsity Athletic Meet East Zone held at BIT Ranchi in December 1991. It is stated that the deponent was though selected to represent the All India Inter-Varsity Athletic Meet East Zone on the basis of her performance in Inter-College Athletic Meet in the year 1991, but she could not participate in the said Inter-Varsity Meet as the conservative family of the deponent did not allow her to participate in the said athletic meet held at Ranchi. So she has herself admitted in her affidavit that she did not participate, but she represented. So, your lordship, as per the corrigendum and the diploma that she holds is misrepresentation of facts, your lordship.
Where is the diploma?
Diploma is at page 97, your lordship.
I'll take a break and come back.
This Your lordship, while taking admission into this diploma course, the respondent applied for this, applied by stating that she has participated in such and such in All India Intervarsity Athletic Meet. But participation and your lordship representation is different. And she accepts her in her affidavit as well.
On what basis you are saying that she got admitted in the sports coaching on that?
There is a form, your lordship. There is a at NHS 7, page 29. RTI application was sought, and after that, the documents which were submitted by respondent number 5 were next along with this. So here, this is the type copy at page 30. At page 32 and 33, your lordship will see at serial number 7, highest personal performance / participation.
Okay.
And as per the corrigendum, it states diploma in physical education. Your lordship, physical education means like sports and nutrition. It includes sports and nutrition, like fitness and all. And sports coaching only involves like aspiring to become coaches or trainers in sports discipline.
No, all these years I've been playing carom and I thought that I was a sportsman.
The carom is a sport.
Carom is a sports.
Sports. Nowadays in one strike, the entire, you may not get the second chance also. This, whoever gets, that's the striker will finish the game. Yesterday I was watching a carom match of a legend. One strike, finish.
It's very good. I'm not out. I'm still in. Yes. That's all.
Yes, Sir Rasha, I would like to place a judgment like for persuasive purpose only. All the judgments are cited here stating misrepresentation of facts at paragraph number.
Mr. Pathak, that election matter we may take up after this.
Good point.
Paragraph 15, your lordship. Your lordship got it.
Yes.
At paragraph 15. Coming to the discussions on the citation by Mr. Ghosh, learned additional government advocate for the opposite parties, relied on the decision in Avtar Singh Supra. Your lordship. Applicability of decision here is already dealt in paragraph 11 above. The decision of Anil Kanvaria Supra involves termination of an employee on undisclosure of pending criminal cases, suppression of material facts, thereby giving a false declaration in deciding the object of required information in attestation form, and thereby declaration to ascertain and verify the character and antecedent of the incumbent to adjudge his suitability to enter into and continue in service. Through paragraph 8 to 16, Honorable Apex Court came to observe as follows. At 8.4, next page, your lordship.
Yes.
Para 8.4, it is stated that so far as the issue of obtaining the appointment by misrepresentation is concerned, it is no more res integra. The question is not whether the applicant is suitable for the post. The pendency of a criminal case proceeding is different from suppressing the information of such pendency. The case pending against a person might not involve moral turpitude, but suppressing of this information itself amounts to moral turpitude. In fact, the information sought by the employer, if not disclosed as required, would definitely amount to suppression of material information. In that eventuality, the service becomes liable to be terminated, even if there had been no further trial or the person concerned stood acquitted or discharged. 13. It is a settled proposition of law that where an applicant gets an office by misrepresenting the facts or by playing fraud upon the competent authority, such an order cannot be sustained in the eye of the law. Fraud avoids all judicial acts, ecclesiastical or temporal. Next page at 8.5 also. the same cited regarding misrepresentation and or suppression of facts. This is my humble submission, Your Lordship, that that her appointment is selection and appointment is illegal and arbitrary. The form is at page 30, Your Lordship, at serial number 7.
Page.
30, 30. No, that's all.
Yes, Mr. Mahanta.
My lord, we are only selecting agency. Your lordship kindly see what is their projected case in the writ petition. She obtain a admission in the institution by back door. So that is not our lookout, my lord. We have to go by the certificate, madam. Your lordship kindly see, your lordship kindly see that their writ petition. What is it? Page 10, my lord, petitioner beg to state that the private respondent has taken a admission of the diploma course in sports coaching in athletics for the sports section in 1999-2000 in the Netaji Subhas Education Center, obtaining a diploma by having submitted false information. So he got, the private respondent got the admission in that institution by giving a false information. My lord, we cannot go to that, my lord. We have to go by the certificate which are annexed, my lord, along with the form as per the advertisement, my lord. It is as per the advertisement, my lord, it is correct or not, that has to be run in look into, my lord. Thereafter, there is an interview and he has been selected, my lord. So that, my lord, we have already answered, my lord, in our affidavit. Because that is not our lookout, my lord. We cannot go to that also. How you obtain that? Suppose someone's annexed certificate and how you, my lord, get admission in that college and what manner. That is not the lookout of the APSC, my lord. So whatever, my lord, that is they are only pleading in the writ petition. But now I came to know that they have, my lord, annexed on affidavit, and annexed reply to our affidavit. They annex one document. They said, now they said, my lord, in their main writ petition, they have not said, my lord. That is not certificate as required by the advertisement. So in that regard, my lord, I cannot give answer, my lord. I have to look into the, my lord, the record, because whether that has been submitted or not, my lord, I do not know. Because it is long back in 2007, my lord. So whether record is also available or not, I do not know. Because that was not reflected in the main writ petition. That's why I am unable to answer, my lord. So that is their document, that, my lord, based, my lord, the private respondent can say that whether what are the document they have annexed, my lord. So document which of annexed by, my lord, the private respondent, we found my lord, that is as per advertisement, and we allow him to sit in the interview, my lord. That is our case. So it is a long pending case, madam. Actually, my lord, I do not know, my lord. Record is also not available with me, my lord. Just I file affidavit that is filed by the earlier council, my lord. So, my lord, as per their writ petition main contention, my lord, how he get admitted in that course, my lord, that is not our subject matter, my lord. So as per advertisement, the requisite document which was submitted by the private respondent, we found it eligible, and accordingly she was allowed to sit in the interview, and accordingly she was selected along with others, my lord. There are 6 posts probably. Recommendation made in the year 2008, and opposed this honorable court in 2014, my lord.
Yes. Originum,
Page 26, my lord. 20, sorry, page 20.
in your affidavit,
My lord,
in your affidavit in paragraph 11,
my lord.
you have said that para 11 of your affidavit,
My lord,
Corrigendum dated so and so, clearly read down that the candidate of the post of district sports officer must be a degree holder in arts so and so from recognized university with a bachelor degree or diploma in physical education.
my lord.
So this, you have to tell us whether this certificate, page 97,
My lord. The reply, my lord.
yes, page 97, whether this is a certificate of diploma in physical education.
My lord. Coca-Cola. That is diploma in sports coaching.
In your affidavit, you say,
My
at
lord,
page 118, paragraph 11,
my lord.
it must be a diploma in physical education.
Yes, correct, my lord. Respondent of 5 eligible as per qualification lived under recognized eco-curriculum dated, hence the respondent of 5 is called for the interview. So, my lord, whatever the document annex, my lord, it was found to be correct as per the advertisement, my lord.
We are not
But I
saying-
don't know whether this is, my lord, first of all, whether it is, my lord, separate degree or there are another document also there, my lord. I do not know, my lord. Because that was, my lord, in the reply only. It was not in the remaining petition, my lord. The contention which was, my lord, they raised in the writ petition and contention which raised now, my lord, in the affidavit in reply is totally different, my lord. And whether diploma in sports coaching and whether diploma in the physical education are one or same. What are the consideration made by the, my lord, that authority? And whether this was annexed with the, my lord, that application form, my lord, or not, that is also I do not know, my lord.
No, this document is produced in an affidavit of the respondent of 5.
My lord.
This is page 97. It appears that is a part of the affidavit of respondent of 5. So she is producing her document to
My
show
lord.
that she only has.
That is the document they have annexed, my
So
lord.
now the question to you is, as a PC, that whether this is a diploma which is in physical education. It is not.
As per advertisement, that is, no, whether that diploma in sports and diploma in physical education one in same, my lord.
No, this is sports coaching. It may be an equivalent,
My
but
lord.
it's not a diploma in physical education.
My lord. In that point, my lord, what consideration, my lord, that definitely that evaluation committee, my lord, they were that tender evaluation committee, sorry, my lord, that sports the application, my lord, when considered, and what are the view they have taken, my lord, and that, my lord, I am unable to
because-
answer right now.
You remember I had a very bad slip disc. And among the other persons, you were also there to tell me that you do this sort of exercise and it will cure you. Now, that is something which is called physical education. You did not teach me how to play sports, but you said that if you are in this posture, you help yourself in hitting your back. So that's basically an education.
My lord.
But coaching would be only to
No,
tell
definitely,
people
my
how
lord.
to catch a bat, how to catch a hockey stick. how to handle a table tennis racket.
Coaching in sports, my lord, that is related to games and coaching
Physical
in physical is
education
related to the body,
Fitness.
is the body.
fitness. That is two different, yes. But I am not answered in my affidavit whether, my lord, that what was the concern, because that was not in the main writ petition. That's why I'm unable to answer, my lord.
Correct. Okay.
Otherwise, my lord, it will be covered in the, my lord, affidavit, my lord. Because there is no provision for, my lord, giving reply to the rejoinder, my lord.
Mr. Mohanto knows the difference better than you. Past
No, not I am, that's why I'm submitting.
What is the difference between like coaching?
No, you see, we don't have a personal knowledge. We are just, it's just because of my past background that I have a tendency to cross-examine.
Yes.
Suppose, my lord, in Indian cricket team,
Personal knowledge, I want to ask a senior counsel to say on personal knowledge, because we don't expect him to have to use his personal knowledge.
in our Indian cricket team, my lord, there is a chief coach. There is a coach, is my lord, he is my lord, Rahul Dravid is a chief coach, and there is a physical instructor, my lord, there is a different, my lord, it's a different post. Yes, that is true. That physical coaching on physical instruction, coaching in sports, and diploma in, my lord, physical education, they're totally different, my lord.
There is another reason why he has earned respect. The reason is that he's a dedicated sportsman, and not only that, I have found him to be present on holidays and Sundays in a particular sports ground,
Yes.
looking after and managing the sports arena. So he's onto physical fitness. Yes. Okay. Yes.
Maybe. Melody, this case is relates to Melody, the advertisement of 2007. And thereafter, Melody, recommendation was made in 2008, and their RTI application that was filed in 2014. And after 5 years of the recommendation, Melody, they have submitted the RTI application, and according to them, they discovered something new in the writ petition, that the respondent number 5 presented her case before the NIS, that she participated in the national events. But if your lordship goes to the form and at page 30 of the writ petition, there in column 7, the requirement is higher personal performance, participation. And she did not suppress anything else before the NIS during her admission. The certificate she submitted that has been at page 34, annexure 8 of the writ petition. It clearly says that she was selected to represent the DU, Dibrugarh University Athletes team for the All India Inter-University Athletic Meet, East Zone, held at BIT, Rasi in December 91. Here it has not been, certificate doesn't say about the participation. Regarding selection, and in my affidavit, I have clearly stated that due to not getting permission from my family, I could not participate in that. And now NIS, how NIS admitted me, that cannot be, and certificate that cannot be challenged here in this writ petition, because NIS is not party in the writ petition itself.
Yes.
Apart from this, if your lordship kindly go through the statements made in the writ petition, nowhere it is, the explanation is made regarding delay in filing the writ petition, my lord. My appointment was in 2009 and it is 2024 now, my lord. It was 15 years have been elapsed, my lord, and I am serving in the post. And not only, my lord, in my case, I was considered on the basis of the NIS certificate. Your lordship may kindly see the statement made in my affidavit, the affidavit of response number 5 in paragraph 7, my lord. There are two other persons also having NIS certificate, and on the basis of that, they were selected. At paragraph 7, I have stated, my lord. Yes.
Mr. Chaudhary, I forgot the track, yeah. Why you did refer to this NIS? You said that NIS is not the party. In which context you said that?
My lord, a certificate issued by the NIS that has been challenged, my lord. Here,
Which
challenge
certificate?
according to them, on the basis of the NIS certificate, I was appointed. And I got the NIS certificate on the basis of this representation of facts.
No, their certificate is page 30.
Yes, my lord. Certificate, my lord. APSC accepted that certificate, my lord, during
Oh,
my.
this page 37, you are referring to page 30 certificate, right?
Yes, ma'am.
Page 30 is the form, your lordship. Application form.
Where is the certificate?
Certificate is at page 97, your lordship. Diploma certificate. Page 97. Your lordship, the petitioner is not stating that the diploma is.
There are two other sports officers also, they were appointed, on the basis of NIS certificate. I have stated in paragraph 7, in respect of the same advertisement and same appointment letter. Their name also appears. That the deponent begs to state that the deponent and two others, namely Sri Manas Putim Das with diploma of NIS gymnastics and Sri Satya Gogoi NIS weightlifting were issued call letters, and they participated in the selection process, and on the basis of their diploma in physical education and training or posts selected by the APSC as their qualifications were found to be in conformity with the said service orders. Accordingly, at present, after about 6 years, the repetition by the unsuccessful candidate putting allegations about furnishing of false documents for admission into NIS course, and that the deponent's diploma in NIS does not conform to the qualification as per the said service order is misleading and painful. As two others of the same footing also were found to be eligible, and they were appointed as district officers, sports officers, and who were serving as district sports officer like the deponent. In respect of their appointment, their cases have not been challenged in this petition, only the petitioners. Respond number 5. Apart from this, in paragraph 2 of my petition, I have made preliminary ground regarding delay in filing the petition. So far the delay is concerned, I cite two decisions.
of the Apex Court. Rabindranath Bose versus Union of India, reported in 1971 SCC 84. I refer paragraph 12 and paragraph 36.
Para 12 and
36. May I read my letter?
yes.
From paragraph 11, I am reading. Although the appointments according to the petitioners were irregular, they do not challenge the validity of the appointments, but what they do challenge is the recognition of the date of appointments for the purpose of seniority. In other words, they say that we may treat an officer having been appointed as class 1, grade 2 validity, but for the purpose of seniority, his appointment should be post-dated to a date when he would have been appointed had the quota rule mentioned in paragraph 2D of the scheme dated 29/9/44 been fully implemented. We may at this stage deal with the particular question. It seems to us that apart from the above limited concession, we cannot at this time declare that the appointments were invalid in any respect. Assuming that these appointments were made contrary to statutory rules, the petitioners are incompetent to challenge the validity of these appointments for various reasons. Firstly, these appointments were pre-constitution appointments and they cannot be challenged in a petition of Article 32 of the Constitution. Secondly, there has been inordinate delay. A suit to challenge the validity of the appointments would be hopelessly time-barred, and the respondents have acquired various rights since their appointments. Thirdly, in Jaisinghani's case, this court said that the order in that case will not affect such class 2 officers who have been appointed permanently as assistant commissioner. We will presently give our reasons in detail for coming to this conclusion. To resume the narrative, the petitioners completed their probationary period on the parentage in 1949, were confirmed as IIT OS class 1 grade 2 in 1949 and 1950, except petitioner number 9. Next, my lord. Paragraph 36, my lord. The learned counsel for the petitioners, however, says that there has been no undue delay. He says that the representations were being received by the government all the time, but there is a limit to the time which can be considered reasonable for making representations. If the government has turned down one representation, the making of another representation on similar lines would not enable the petitioners to explain the delay. Learned counsel for the petitioners says that the petitioners were under the impression that the Departmental Promotion Committee had held a meeting in 1948 and not on April 29, 1949. And the real true facts came to be known in 1961 when the government mentioned these facts in their letter dated December 28, 1961. We are unable to accept this explanation. This fact has been mentioned in the minutes of the meeting of the committee, which met in February 1952. We are unable to believe that the petitioners did not come to know all these facts till 1961. Here, in this case, also, the appointment recommendation there, those were made in 2008. Apart from me, 2 other officers also were also appointed on the basis of the same certificate. But they have explanation only just there is no explanation in the petition, only just they have said that the RTI application has been made in 2014 and thereafter the petition has been filed. So, my lord, since recommendation, my lord, up to the filing of writ petition, there was 6 years delay, and there is no proper explanation in the writ petition. The other case also, my lord, that is a state of Maharashtra versus Digambar. It was reported in 1995 for SSC page 683.
Yes.
And I refer paragraph 12 and 16, my lord. Paragraph.
Yes.
How a person who alleges against the state of deprivation of his legal right can get relief of compensation from the state invoking jurisdiction of the High Court under Article 226 of the Constitution, even though he is guilty of losses or undue delay, is difficult to comprehend. When it is well settled by the decision of this court that no person, he a citizen or otherwise, is entitled to obtain equitable relief under Article 226 of the Constitution, if his conduct is blameworthy because of losses, undue delay, acquiescence, waiver, and the like. Moreover, how a citizen claiming discretionary relief under 226 of the Constitution against the state would be relieved of his obligation to establish his unblameworthy conduct for getting such relief, where the state against which relief is sought is a welfare state, is also difficult to comprehend. Where the relief sought under Article 226 of the Constitution by a person against the welfare state is founded on its allegation illegal wrongful executive action, the need to explain losses or undue delay on his part to obtain such relief should, if anything, be more stringent than in other cases, for the reason that the state, due to losses or undue delay on the part of the person seeking relief, may not be able to show that the executive action complained of was illegal or correct, or for want of the courts pertaining to the case, or the officers who were responsible for such action not being available later on. Further, where granting of relief is claim against the state on alleged unwarranted executive action is bound to result in loss to the public exchequer of the state or in damage to the other public interest, and the High Court, before granting such relief, is required to satisfy itself that the delay or losses on the part of a citizen or any other person in approaching for relief under Article 226 of the Constitution on the alleged violation of his legal rights was wholly justified in the facts and circumstances, instead of ignoring the same or leniently considering it. Thus, in our view, persons seeking relief against the state under 226 of the Constitution, be they citizens or otherwise, cannot get discretionary relief obtainable thereunder unless they fully satisfy the High Court that the facts and circumstances of the case are clearly justified the losses or undue delay on their part in approaching the court for grant of such discretionary relief. Therefore, where the High Court grants relief to a citizen or any other person under Article 226 of the Constitution against any person, including the state, without considering the blameworthy conduct, such losses and or undue delay, acquiescence or waiver, the relief so granted becomes unsustainable, even if the relief was granted in respect of alleged deprivation of his legal right by the state. Paragraph 16, coming to the exercise of power conferred upon the High Court under Article 226 of the Constitution for issuing orders, directions, or writs for any purpose. Such power is discretionary, being a matter well settled, cannot be disputed. Power of the High Court to be exercised under Article 226 of the Constitution, if it is discretionary, its exercise must be judicious and reasonable, admits of no controversy. It is for that reason a person's settlement for relief from a High Court under Article 226 of the Constitution, be it against the state or anybody else, even if even if is even if is founded on the allegation of infringement of his legal right, has to necessarily depend upon unblameworthy conduct of the person seeking relief, and the court refuses to grant discretionary relief to such person in exercise of such power when approaches it with unclean hands or blameworthy conduct. Here in this case also, my lord, there is no explanation in the reason why 6 years delay was caused after the recommendation of 3 persons, not only myself, 3 persons for appointment of district officers, district sports officers. Now, my lord, I have served, my lord, for 15 years, my lord, after my appointment, and I am continuing service, my lord. So whether due to delay in filing of the writ petition, that my present positions that can be altered, my lord. That is my humble submission before this honorable court. And since APSC also accepted that on the basis of our certificate, we were found eligible for appointment and accordingly appointed. And 3, not only me, myself, and 2 others also were appointed on that basis. And they are also continuing at present. This is my humble service.
There's a question. In this case, when there's a service rule,
Yes, sir.
service order, which prescribes particular qualification, and if one does not have a qualification, according to you, it will be irregular appointment or illegal appointment?
The APSC, on what basis it was considered, we also do not know. But
No,
our,
it's not on that. What they consider is not the question. The question is that
if
there's an advertisement, it says a qualification, it says
Without-
a corrigendum.
without
says a
conformity of
qualification.
law, if someone is appointed, then it is illegal, I should consider it. I can say, it is irregular. The judgment I referred, in that case also, Apex Court says, irregular or illegal, both has been included,
Hmm?
In the first judgment, it was stated by the Apex Board.
Which part? Para 12 and 36. Because in para 11, it says irregular, it doesn't say illegal. Illegal word is there, I missed it. Para 11, you will find irregular. Illegal, if word is there, I have missed it.
Yes.
Yes, Mr. Goswami, you have anything to say?
Involvement Dibugan University, the certificate issued by Dibugan University has been used to obtain admission in the diploma. Clarified my position that this was the simple study the academic. She was selected to represent, but actually did not participate. According to an access showing the names of 4 persons who had actually participated in that inter-university match. And this has also been admitted by the prisoner fight that she could not participate. That is the link for limited point.
Yes, Mr. Kaur, you want to supplement anything?
No, well, I'm happy with what she has submitted. She will like to make a short reply. Let her have her day today.
Okay.
At least back in our chamber, we can have tea and coffee from her.
Few submission, Your Lordship, I'd like to make. First of all, Your Lordship, there is no straitjacket formula as to the like the limit provided to file for filing of the writ petition. It depends on the facts and circumstances of the case. And Your Lordship, if Your Lordship will peruse page number 106, we have replied to the affidavit of R5 stating the delay, Your Lordship. We have applied for the RTI application when it came out to our knowledge that regarding the illegality of R5, and immediately in 2014 only in June we have filed the writ petition at para 3. And these documents are not available in the public domain, Your Lordship. So we have to file the RTI, and directly in RTI also that reply was not given. Then we sought for the appeal. We filed an appeal, and there also regarding the representation, we made certain clarifications to that. And then when we came to the findings and all, we approached this honorable court as soon as possible. And Your Lordship, if this diploma is illegal, then she does not hold any other post other than the bachelor degree. So we are not on that the diploma is illegal. The diploma is genuine, but we are on that the corrigan, it is not as per the qualifications mentioned in the corrigendum. And regarding the other 2 applicants, we are not on that, Your Lordship, because 2 wrongs will not make one thing right. So I leave it to the wisdom of the honorable court.
Your name?
Miss S. Jain, Sanjukta Jain.
I think that will suffice our purpose, madam. If it's dismissed, my name will be recorded. If it's allowed, my junior's name will be recorded. I'll take the blame for dismissal.
So I got the names, S. Jain for the petition. Mr. B. Chaudhary for the respondent. Number 5. Mr. T.J. Mahato, along with Ms. A. P. Sharma for respondent number 4. Mr. R. Goswami for respondent number 3. Mr. C.K.S. Barba, 1 and 2. You have anything to say, Mr. Sharma Barba?
Yes, we have submitted that they listened to APS and New Delhi. So we are under their light also.
You only add one tail, your affidavit. You say that the petitioner is not qualified. There is a tail you have added in your affidavit.
Well, the beauty of this profession, I have my teachers sitting behind. Then I am not behind. We are all colleagues. We are all colleagues.
That's good. We all, there's one good thing about Mr. Pathak is that he wants to encourage young
Yes.
people to
My-
come forward.
I am always obliged to him as a teacher.
It's a good part to see others grow.
Yes.
And it's good that you gave her an opportunity of arguing. That's also good. Chalo.
May it please the court. Item number 8 and 9, I have initially in the morning, I had mentioned without taking the consent of the other side, but today he's here. Your Honor. Mr. J.K. Goswami is supposed to go through the records and all, after that indicated, if a short date accommodation can be given.
2 weeks. On the prayer contract admitted.
I am appearing for the case in both the cases.
What's his representative?
Obliged.
Lovely.
Item 17 upgraded.
Yes.
Today I will just sum up. I will not go to the decisions right now because all those decisions I have shown it to your lordship. 2002 Apex Court directed the Election Commission of India to make provision for declaration of 4 more additional information. But initially at that stage, the consequences of non-declaration, misdeclaration or false declaration of those 4 informations which were directed to be disclosed were not given. So this situation continued from 2014 to, I will not go case-wise, 2014 to 2018. Non-declaration, misdeclaration and false declaration of these 4 informations were brought within the definition of corrupt practice of undue influence. So as your lordship is aware that corrupt practice of undue influence, corrupt practice as such is a defined concept in the RP Act. There are 7 types of corrupt practices, and these corrupt practices were defined because it has relevance to Section 100 of the RP Act. Section 100 says what are the grounds on which an election can be declared void by your lordship. So 101 B for Bombay, it says that corrupt practice is a ground for declaring an election void. And what is corrupt practice? We get in Section 123. There are 7 types. It starts with bribery, then undue influence, and all these 7 types. All these 4 informations, if there is a misdeclaration, non-declaration, or false declaration, were brought within the definition of corrupt practice of undue influence. Meaning thereby that a legal fiction was created within the definition of 123 of the RP Act. At that stage, there was a confusion at the bar, not only in this High Court, but also in different high courts all over India, that if an allegation is made
for false declaration, non-declaration or misdeclaration of those information, whether the requirement of section 83 for pleading a material fact and material particulars are waived or not. That was a state of confusion that remained at the bar all over India. Because this confusion was there at the bar because in all 1980s case up to 2000, all those decisions, section 83, the requirement of material fact was held to be mandatory, and particulars, if it is there, it can be amplified later. Suppose a corrupt practice of bribery, he has to, that was the position, he has to state that how, when, how and, I'm so sorry, how and in what manner the bribery was there. These falls within the parameters of material facts. When, where, how, at what time, these are material particulars. So material particulars can be amplified. If it is something is there, it can be amplified. Material facts have to be there. But a gray area by way of a confusion at the bar started coming in, that whether that material fact is still required or not. So,
you can go, we'll call you.
because I'm not taking your lordship valuable time to go through all decisions. Now, I was fortunate enough when this confusion was before appear before this court as well as before the Itanagar court. Here, I took up a point that in Guwahati court, in the Guwahati bench, the point was educational qualification, non-disclosure of bank account and assets. All these allegations were there, whether material fact will be necessary. Similarly, when I appeared at the time of the final hearing in Itanagar, that argument I still took. So in Guwahati, it was an order 7 matter. In Itanagar, it was a final hearing. So in Guwahati matter, ultimately went to Supreme Court. Supreme Court in the Guwahati matter, that is election petition number 1 of Guwahati, from, if my recollection is correct, from paragraph 19 onwards, it is, if it is there, I will just check up my, if that judgment, because earlier judgments are, that is page 77 of my synopsis to the one. Written synopsis.
The new compilation.
New compilation. It might be my recollection may be wrong, or the memory may fail me also. I remember it was paragraph 19. Yes.
We use the terminology before memory.
My lord.
Before memory fades. It can't be memory fails.
Memory. My lord. Now I am doubting my own memory at times very often. At page number is 93.
So I'll encourage you to write something before memory fades.
Before, yes, I definitely, my lord, before memory fades. But I have got a peculiar distinction from my High Court. It was before Honorable Justice Sharma, P.K. Sharma. I was called in as an amicus in a foreigner's matter, foreigner's trial. I do not know in what mood I was there. Then the judgment says that computerized memory of page number 93, it says, paragraph 19. Now, from the bare reading of the election petition, that is the election petition number 1, my lord.
You perhaps have the distinction of being the first counsel in this court to have a computer.
My lord, I know, but I do not know. My son, my children are angry with me nowadays. My office
No, that's
had
okay,
it.
but you have a distinction of having the first
Yes,
computer, in the first chamber with a computer.
yes, ma'am. That is correct. That is correct. So, but paragraph 19 says, but may I just take 1 minute, ma'am? The tricks of memorizing is what you think that you are not remembering something, relate it to something what you remember. Like I was from a vernacular school. There was a word called inendo that was in torts, defamation. So for the exam purpose, how to remember it? I had a friend called Bimolendu. So immediately I will remember, oh, that Bimolendu is the inendo. But otherwise, if you try to remember, like for execution of, I'm sorry, my lord, just I love her, in fact, just for execution sections of the CPC, how do you remember? The substantive sections are Brahmahanka Aibolang 36, 3 plus 6, 9. Then multiply it by 2, up to 72. This time add 2, 74. So 36 plus 2, 72. First time you multiply, next time you add 74. Then you get the substantive provision related into execution. This is how it can be memorized. Anyway, sorry. Paragraph 19. Now, from the bare reading of the election petition, that is the election petition number 1, my lord, it emerges that the respondent number 1 has made only bold and vague allegations in the election petition without stating the material facts, as your lordship. In support thereof, as required to be stated under 83(1) of the RP Act. Apart from the fact that none of the allegations with regard to the false statements and suppression and misrepresentation of facts allegedly made by the respondent number 1 with regard to his educational qualification or with regard to his liability in respect of the loan availed by him for his partnership firm or with regard to the default in depositing employers' contribution to provident fund would fall within the definition of corrupt practice, as your lordship. These are corrupt practices of undue influence as envisaged under so-and-so of the election petition. Also lacks, your lordship will carry, also lacks concise statement of material facts as contemplated in section 83A and lack full particulars of the alleged corrupt practice as contemplated in so-and-so. Next paragraph, final. So far as the allegations of corrupt practice are concerned, the respondent number 1 was required to make, your lordship will say, required to make concise statement of material fact as to how the appellant had indulged into corrupt practice of undue influence by directly or indirectly interfering or attempting to interfere with the free exercise of any electoral right. Mere bold and vague allegations without any basis would not be sufficient compliance of the requirement of making a concise statement of material facts in the election, because allegations are there. That has to be now converted to material facts and particular. The material facts, which are primary and basic facts, as well as have to be pleaded in support of the case set up by the election petitioner to show his cause of action. Any omission of a single material fact would lead to an incomplete cause of action, entitling the returned candidate to pray for dismissal of the election petition under Order 7, Rule 11 of the CPC. Now, your lordship will kindly come to page number 96. Has your lordship?
Yes.
Now, just above paragraph 22, there is a sentence starting from, if it is found, has your lordship, if it is found, if it is corrupt practice in the nature of undue influence, the pleadings must state the full particulars with regard to direct or indirect interference or attempt to interfere by the candidate with the free exercise of any electoral right, as stated in section 123(2) of the Act. We are afraid Mr. Gupta has failed to point out from the pleadings of the election petition as to how the appellant had interfered or attempted to interfere with the free exercise of any electoral right so as to constitute undue influence under 123(2). Now, so far as the ground of contained in clause D of section 101 subarticle 1 of the Act with regard to the improper acceptance of nomination paper. May I just pause here for a moment? This is corrupt practices under 101B, B for Bombay, and improper acceptance, like the substantial defect, improper acceptance. Then in improper acceptance, what will happen? Because there was a prayer under 101B and also a prayer under 101D1, improper acceptance. Now, paragraph 22 says, so far as the ground contained in clause D of section 100 subarticle 1 subsection 1 of the Act with regard to improper acceptance of the nomination of the appellant is concerned, there is not a single averment made in the election petition as to how the result of the election, insofar as the appellant was concerned, was materially affected by improper acceptance of his nomination, so as to constitute a cause of action under section 101D1 of the Act. I'll just pause here for a moment. If it is corrupt practice, apart from material facts, this particular further requirement is not necessary. But for improper acceptance, this further pleading will be necessary. Though it is true that the election petitioner is not required to state as to how corrupt practice had materially affected. If it is a case of corrupt practice, he is not required. It is a corrupt practice, corrupt practice. But if it is an improper acceptance, then an additional requirement. May I take your indulgence, my lord? If I take your lordship to section 100, RPF. এখন আৰু এক কপি আছে That will come to section 100. 101B, B for Bombay, that any 101B.
Yes.
That any corrupt practice has been committed by a returned candidate or his election agent, then you lordship can declare void. Now, 101(2), subsection 2.
Yes.
Second alternative is, if in the opinion of the High Court, a returned candidate has been guilty of any agent or has been guilty by an agent other than his election agent of any corrupt practice. This is 2. Then, but the High Court is satisfied, as your lordship, that knows, I'm so sorry, I went to some 100 subsection 1D. After your lordship has gone to B, then D. That the result of the election insofar as it concerns a returned candidate has been materially affected by an improper acceptance of nomination. There is a distinction between B and distinction between D1. Corrupt practice, this additional requirement of how it affected materially the result of the election is not there. In the backdrop of this statutory provision, I take your lordship to paragraph 22. My lord, has your lordship. So far as regards the ground contained in clause D of section 101, this is improper acceptance, my lord. Has your lordship.
No, I'm thinking something else. Same which came earlier also, same query. You see, X files a nomination paper. It does not give an affidavit. Then it is accepted. So therefore, to show something more. That how the election will be materially affected.
My lord,
Something is,
I'm obliged. I'm obliged for this query. Pratibha. First is there is a question of next highest rule. Next highest rule. Suppose it was, if he says that it got materially affected because I got 10 votes, he got 12 votes, other person got nil. The Supreme Court in that are given in the, it's a question next highest vote. So suppose I got 7, other man got, the higher return candidate got 10 votes, I got 5, and other man got 4 or 8. Then he has to burden a little more on him to show that he would have these votes, which
Would have
are
crossed over
wasted,
to-
would have come in his favor. But he has to plead that how these things materially affected. But if he's silent, merely saying it's an improper acceptance, it will not be sufficient. He has to plead the material fact. That is a proving part, but he has to say something that it has been affected, materially affected. And because this is my number, I am the second highest or third highest, this vote also gone. So therefore, I come in. Now, paragraph 22 is dealing with that part, my lord. Your lordship will see.
Because
This
it's
query
merely a-
came up in the apex court also,
it's merely a presumptive argument.
my lord,
It's merely a presumptive argument.
my lord. Because Supreme Court here dealt with that first the burden is on you, that it got materially affected. Merely saying that it is an improper acceptance, that is not sufficient. That is what paragraph 22 is. I am obliged for, because this query was argued at length also. That whether this is additionally required to be pleaded. Then it was ultimately accepted that this forms a material fact. That it got materially affected. You cannot remain silent.
Because
And
there's a-
how it got,
So there is a legal provision, we can't say it does not apply, but
my lord.
how will somebody prove it?
Proving next come. First you step into the picture. That I come in, this is how it got materially affected. My lord, may I take paragraph 22 only? Page number 97, my lord. There is not a single averment, paragraph number 2, made in the election petition, your lordship will kindly allow, as to how, your lordship, as to how the result of the election, in so far as the appellant was concerned, was materially affected by improper acceptance of the nomination, so as to constitute a cause of action under section 101 D1 of the Act. Then, though it is true that the election petitioner is not required to state as to how corrupt practice had materially affected the result of the election, nonetheless, it is mandatory to state when the clause D1 of section 101 is invoked as to how the result of the election was materially affected. Now, here I pause here for a moment. Suppose an election petition, to fit into the section, it says it got materially affected. Is it a complete, can it give rise to a complete cause of action? Here it was clarified. Merely saying it got materially affected is not sufficient. As to how it got materially affected, your lordship will see. How? Merely saying that, quoting the section, that it got materially affected, that by itself will not be sufficient to constitute a cause of action. As to how the result of the election, there has to be material pleadings, material facts. If I'm clear. Now, your lordship will kindly see paragraph 24 at page 98. This I remember, my lord, in another election case, of course, that was ultimately that most probably election petition was dismissed because of limitation ground. There was that question, my lord. Now, although it may not be, it will be relevant. I'm sorry. Paragraph 24. As stated earlier, in the election petition, the pleadings have to be precise, specific, and unambiguous. If the allegations contained in election petition do not set out grounds, as well as this setting out requirement of setting out grounds come from section 81. Your Lordship will kindly look at section 81.
Grounds of
Grounds. So here, in this case, also Apex Court has gone to say that it does not set out grounds. Therefore, in my earlier arguments also in the other case, I said there was a art of drafting the election petition. First is material facts, then side by side is material particulars. Then we used to make a separate chapter called grounds. Then affidavit, verification and all. Now, in the other ideal case, Itanagar case, my lord, it starts from page 100. Only one paragraph I want to see. So, the Itanagar case starts paragraph 45 at page 135. I'm sorry, paragraph 44, one page 134. There, the question of a pen, someone having a pen of say 1 crore rupees. I am having a pen of say at the most 15 rupees because I always lose a pen. Now, person may be having a 1 crore rupee pen, but that by itself may not be, if it is not disclosed, may not be a corrupt practice. But moment he comes and shows that, look, I am a person with this social status having a 1 crore pen, Mr. Pathak is having 25 rupees pen. That becomes a corrupt practice because he has not disclosed that. So now paragraph 44. Though it has been strenuously contended before us, has a lordship.
But that itself is an answer of your first statement that you have a habit of losing pen. Try to have a costly pen, you'll never lose it.
My lord, I lose everything. Other day I have lost my valuable things while even traveling in the flight. I kept it in the pocket, then I don't know in which flight I left it. Paragraph 44, my lord. Though it has been strenuously contended before us that a voter's right to know is absolute, and a candidate contesting the election must be forthright about all his particulars, we are not inclined to accept the blanket proposition that a candidate is required to lay his life out threadbare for examination by the electorate. His right to privacy would still survive as regards matters which are no concern into the voter are irrelevant to his candidature for public office. In that respect, non-disclosure of each and every asset owned by a candidate would not amount to a defect, much less a defect of substantial character. Substantial character issue comes because of improper acceptance. That is, if it is not necessary that a candidate declare every item of movable property that he or his dependent family members, such as clothing, shoes, crockery, stationery, furniture, unless the same is of such value as to constitute a sizable asset in itself or reflect from his candidature in terms of his lifestyle or required to be disclosed. Every case would have to turn on its own peculiarities, and there can be no hard and fast or straitjacket rule as to when the non-disclosure of a particular movable asset by a candidate would support to a defect of substantial character. Now, your lordship will kindly see, here also, they have asked for another relief, is 101 D Roman 4. D Roman 4 is if it is in violation of any statutory rules. Take one, D, Roman protocol. Has your lordship. By any non-compliance with the provision, has your lordship. Now here also, he has to prove that how the result of the election got materially affected. Because basically, in 1970s and 80s, we remember that Apex Court was of the view that the mandate of the electorate should not be lightly touched. Therefore, this additional, if your lordship looks at the parliamentary debates in India, this additional requirement that, okay, and this is in violation of some regulation, but kindly tell us, kindly state how it got materially affected. Has your lordship, 1D. Now, in paragraph 45 also, this will be necessary. I am now coming, my lord, to the present case. I'm coming to the present case and I'll finish it in another 10 minutes. My lord, if I have gone through the election petition, altogether there are 39 paragraphs. Basically, there are 4 allegations. First allegation is, I have disclosed 3 FIRs, but have not disclosed, I have disclosed one or 2 FIRs, but I have not disclosed 3 FIRs. The requirement of disclosing the FIR is under section 30, is under section 36. No, 33, 33. Let us now see what is the law relating to requirement of disclosing of FIR. 33, no. 33A. I'm sorry, 33A. Section 33A.
Gotcha. Yes.
The requirement, let us understand. If I read it slowly, my lord, it appears like this. Roman 1. If he is accused, right to information. If he is accused of any offense, punishable with imprisonment for 2 years or more in a pending case. Now the word pending has been now qualified. In a pending case in which a charge has been framed, as a lordship got, by the court of competent jurisdiction. I am not reading out the next one regarding conviction. Coming to his case, the election petitioner saying that I have disclosed 1, I have not disclosed 3. Now the requirement as per Joshi's case, if a lordship comes to page number 20 of my written argument, I am dealing with the allegation wise, because that is in serial number 7, serial number 6 at page 20 to 20. Has a lordship the front page. Page numbers, serial number 6 is I am dealing with allegation relating to non-disclosure of FIR.
Yes.
Now, what was required to be pleaded is that I have not disclosed 3 FIRs with regard to offense which is punishable with 6 months, with 2 years or more. This is pending in a court in which the charges have been framed. These are absolutely not pleaded. Now, I am not taking a lordship. Now, what is important here is none of the material facts of this, that this is a 6 months or more, 2 years or more, pending in a court in which the charges have been framed, nothing is stated. It is statement from the bar. I have checked up. Nothing is stated apart from the certain judge, because earlier judgments also I have quoted at page number 22 and 23, but recent judgments also I have the requirement of material facts. Actually, this material facts concept, the requirement of Haridwar Law was the first case. Now, second allegation is, my lord, I am dealing with it, page number 24. What is the second allegation is, the page number 24. His allegation is that I have failed to disclose movable and immovable property in the nomination paper. In page number 28 onwards, 24 onwards, I am handling what is his allegation regarding my movable. He has one allegation. He says, I'm not going page by page. He says that I have disclosed my cars. I have given the, what is the make of my cars, Maruti or whatever. I have given the total value, but I have not given value car-wise and purchase here. Your lordship is, how is it relevant when I have disclosed that? And there is no material fact statement from the bar, that no material fact as to how, in what manner, when, at what time, before whom I have utilized this non-disclosure, this way or that way. What was non-disclosure? That year-wise purchase I did not give. Car-wise value I did not give, but I have disclosed. He says you might have disclosed. You might have given the total value, but not the car value of everything. Now, regarding his immovable property, that can be classified, that starts at, my lord. My lord, one more submission here. In movable, I have, my lord, I'm sorry, before you, in page number 24 of the election petition, your lordship will get it in page number 24, and his election petition also, page number 24. He says this is a substantial defect. Substantial defect results in improper acceptance of nomination paper. He has not says how the result of it is materially affected. Now, at page number 24, that is paragraph para 14D, your lordship will, in the election petition says, this is improper acceptance of nomination paper. This is the substantial defect. He makes a somersault in the election petition itself. In the affidavit, he says it is a corrupt practice of undoing. If it is corrupt practice, then he is not required. In the affidavit at page, the lordship will kindly see. At page 55 of the election petition, if I take your lordship to the election petition, page number 24 of the election petition, it's a substantial defect. Has your lordship.
54 of the.
At page number 24, he says non-disclosure of movable property is a defect of substantial effect in the first subparagraph of page 24, election petition. If my noting is correct. In the first subparagraph of paragraph 14D, page number
Yes.
23. Paragraph 14D starts at page number 23. Relevant page is page 24. First subparagraph, has a much.
Yes.
He says it's a substantial defect under section 36(4). Now, as your lordship is aware, if there is a substantial defect in the nomination, maximum consequence will be improper acceptance of nomination. But your lordship will kindly see at page 55. He is now changing his stand. Paragraph 14D has been shown as your lordship got it.
Yes.
Now he changes his stand, saying that it's an undue influence, corrupt practice of undue influence. Without realizing the fact that substantial defect has to result in improper acceptance and corrupt practice, the further requirement of how it got materially affected, you are not required to state anything. Now he's changing his stand in the election petition, and it's like a quasi-criminal. Your lordship has gone through all this. I do not know which is exactly he's trying to bring in. And there is no material fact how, in what manner this becomes a corrupt practice. How, in what manner the electorate was unduly influenced by me not giving year of purchase for every vehicle. Now, coming to the immovable property that starts at page number 28. Of my written note, my lord. He has two sub-classification in immovable property. Paragraph 14E of his election petition at page number 24.
Yes.
He says, page number 73, 74 of the, I have given in my note, my lord. He says that I have stated that I have a non-agricultural land. Let us understand his allegation against me. He has said that I have stated I have a non-agricultural land. But in the column, the amount spent for development in that land, I have not stated it. And my submission in the written note, I have said that when he makes this allegation, apart from all those how and it has influenced others, I am not on that. It will be mere repetition. He has gone on a hypothesis while making this allegation that a person must buy a non-agricultural land first, vacant, then he must invest something to make a building, two-story. He cannot think of the other alternate situation. The person buys a non-agricultural along with the house. So here he says, I have disclosed non-agricultural land, but the amount invested for development of the land, and I have also stated that there is a building. He said, but development clause, you have not said zero. Therefore, the third clause, he said it is zero. Therefore, you have is in violation of non-disclosure of non-agricultural land. And here, that is his allegation. My lord will look at page 28. I have already given the synopsis. Now, the third allegation is allegation of page number 30, my lord, as your lordship. Page number 30.
Yes.
Allegation of non-disclosure of contractual details of the return candidate. Let us understand what is his allegation. I am making a summary of it, man. He says that in my nomination paper about my subsisting contract, I have stated nil at page number 78. But he says that amount receivable from HPC I have shown as 3 crores. Without realizing the fact that HPC is already gone on liquidation. Subsisting contract, I do not have anything. He says that because you have said that you have an receivable amount, that means you are not disclosing your subsisting contract with HPC. Here also, my lord, the same, the material facts, how, where, when, all these things are not there. Again, I am not repeating. Now, your lordship will come to page number 32. Here is a peculiar allegation which I have come for the first time, but in India, it is for the 4th time, this allegation. What happens is the spelling is two spellings. Here, his allegation is that I have signed as Nizamuddin NIZ, but in the affidavit as NIJ. Here, he has lost sight of the fact while raising this, apart from those common arguments, that in the nomination, in the list of contesting candidates, already photographs and party symbols are given. He has lost sight of the fact that there is no other Nizamuddin or Nizamuddin candidate. He has lost sight of the fact that in the nomination, in the vote, what is called EVM machine, even the party symbol is also there. He has not said who, how, when got influenced, in what manner that I, an illiterate person signing as NIZ and NIJ had a bearing on the election result. Well, the judgments I'm not reading out because Kedarnath and 2 others are there, precisely on the same point at page number 33. Now, he says it is a corrupt practice. How it is a corrupt practice? Who has committed it by giving this? These things are not there. One, these are the main allegations. Now your lordship will kindly come to the, I have some legal submissions at page number 43 of the written argument. My lord will see the election. May I take your lordship to the election petition also? Election petition, there are altogether, there are 40 paragraphs. Election petition answer 49.
Yes.
The entire election petition is drafted in a writ petition style without stating the grounds. Now, this recent judgment also said it has to be on grounds. Election petition, they have written 40 paragraphs. There are no grounds, and requirement of ground is in section 81 itself, and whether it is mandatory or not, that already Apex Court has laid it down now. And my lord, last one, it will be, I know, at page 47. This is my last.
Yes.
Out of these 40 paragraphs, some are not verified, some are not affidavit. My lord, they can in fact correct it later on, if ultimately. I'm not on that, you cannot correct the paragraph numbers. I will, although I have to argue, I have argued the last point. But now, tomorrow,
She's ready. You can't underestimate her.
Printed, if lordship, Miss Lordship, my senior will.
No, she will argue. I will assist.
She's ready to argue.
My lord, she has to argue.
Only because you suggested that some other day she's
His
postponing.
Lordship, Miss Lordship on 20th of June, Lordship, Mr. D. Saikia, Senior Counsel.
20.
20, Lordship.
More nathakile teo kori দিব। If your lordship, in case I am not there, your lordship will excuse my colleague will be here. Because basically I have given a written argument also. But all the argument, my lord, what is important is 6, 7, 8 serial number. Allegation wise I have dealt. One good thing has happened that when we go online like this in the what is called, they can again see it, what was the argument, so that they can well prepare it.
It helps us also. When we miss out something.
That was what was argued exactly.
it is our-
But one,
Daniel?
The petitioner was initially appointed as a clerk at the UCO Bank on 16/5/1978. And thereafter, he was promoted to the junior management at grade scale 1. And then he was promoted to the middle management grade scale 2 officer. And thereupon, he took charge at Mukalma branch on 14/8/2004 as assistant manager, my lord. And whereby he was serving as assistant manager of UCO Bank at Mangalore branch in the middle management grade scale 2. And thereupon, a disciplinary proceeding was initiated and he was removed from the service. And whereupon, against this removal, we have filed a writ petition number 1723 of 2009, which the court dismissed the case by not interfering with the disciplinary proceedings. Lordship, the petitioner was removed from service on 4/3/2008. And thereafter, Lordship, we have filed a representation, that is the first representation at page number 26, dated 2/9/2013. Lordship, may kindly take to page number 26, my lord.
Uh,
In the bottom, my lord,
you,
bottom page of page number 26, annex number 4. my
20?
lord. Lordship,
20?
page number 26, my lord.
26.
That is the first representation that we have made on 2/9/2013. In the bottom part, my lord, in view of the above, that was my prayer. I would like to humbly pray your good self to impose the penalty as proposed in charge number 4 by recalling the earlier punishment on humanitarian ground and provide the other service benefits such as gratuity, provident fund, pension benefits, etc. That was this prayer, my lord. Lordship, may kindly come to page number 27. That is another one of the representation that we have made in the subject reinstatement of my service to lower grade from scale 2 to scale 1 and or to provide me other service benefits. And this representation we have made in the zonal office, Jorhat. And thereafter, my lordship, may kindly go through my additional affidavit at page number 31 to 33.
what is, according to your rules on, on termination of your service, what is
Yes.
the benefit you get?
Your lordship, I'm entitled to the pensionary benefits.
Pension you may not get. You are removed from service, your total tenure of, you joined in 78.
Yes, my lord.
Where is your service rules? Where is the order of termination?
Lordship. Lordship, page number 15. Lordship. Just a minute, my lord.
No, Mr. Sharma, in the order of termination, which is the final order in the departmental proceeding of 4/3/2008,
Yes, sir.
you have not withheld his payment of terminal benefits. Okay, yes, Mr. Sharma.
Yes, your lordship.
Yes, what do you have to say?
Your lordship, that they have been removed from the service as it has been stated at page number 14. And thereafter they have filed one writ petition that was also been come to dismissal, your lordship. And thereafter they have never applied before us for any retirement benefits or anything. That is a page number 26 and 27, your lordship. Their heading is not as an application for release of the retirement benefit, your lordship.
Correct, but after the court order, they have done it.
Yes, my lord.
Yes, your lordship. And by way of an additional affidavit, they have filed one application before us in the Mukalma branch. And only on before the last date of the order, on before one day, we personally went to his house. That the petitioner is not in a position to come to the branch. So we personally went to his house and collect the documents which we required to process. And that day, your lordship, we kindly refer to the last order dated 14/5. And thereafter, the matter has been proceeded to the zonal office and instantly it has been sent to the head office for further processing, your lordship. And since the matter is very old, so there isn't some problem was there to trace out the document and his service record and all. Because in page number 26 and 27, he himself is speaking about his reinstatement. And the application was moved at the Jorhat Zonal Office. So till 14/5, we are in just collection of the documents.
Okay. That's right. Your name?
Lordship Valentina Villabino Tanyu.
Okay, let's see. Okay. Good. Mr. Ansel, under counsel for the petitioner. Next part. Next para. Mr. M. Sharma, Learned counsel for the UCO Bank, has submitted that during the pendency of the writ petition, for the first time, pursuant to order dated 29/8/2023, the petitioner had submitted an application before the Mukalma branch of UCO Bank for release of pension and other retirement benefits. Full stop. It is submitted that as the service of the petitioner was terminated pursuant to a disciplinary order passed. Sorry, departmental inquiry, pursuant to a departmental inquiry, while order dated 4/3/2008. The respondents require some more time to process the pension papers. To stop by referring to the order dated 14/5/2024, it is submitted that the zonal office has already taken a decision for grant of pensionary benefit to the petitioner. Thereafter, the matter has been sent to the head office
Yes, your lords.
for the appropriate decision. Next paragraph. Accordingly, on the prayer made by the learned counsel for the petitioner, we give a date after 2 weeks. List on so and so as to enable the learned standing counsel for the UCO Bank to inform the court about the status of the decision on the payment of pension and other retirement benefits to the petitioner. Next paragraph. The learned counsel for the petitioner. Sorry, the counsel for the respondents shall send a downloaded copy of this order to the head office of the UCO Bank so as to enable them to provide appropriate instructions to him for being placed before the court on the next date of listing. Next one, list on
21/6.
21/6/2024.
Your Lordship, can it be on the last part of this?
Make it otherwise they will not work.
And
Your
Your
bank will
Lordship,
not work.
I have been directed to serve the copy on the head office, to give the copy.
You can mail it, you can WhatsApp
Via
it.
journal office may be given, Your Lordship, via journal office through. Because I do not have the direct, in the periphery of the head office, Your Lordship.
You say to the zonal office. Okay.
Hello.
Item 11.
I am for the respondent of 5, my lord, private respondent. I have the instruction, my lord, that the petitioner is no more in this case. My lord. The petitioner, my lord, he is no more, but he has expired, my lord. Probably, my lord, this
Is
petition has.
expired.
Yes, my lord.
I have, actually, I have gathered this information today. There is long communication gaps, the old building order matters, my lord. So 2 weeks may be granted. I will confirm, then, if it is so, then I want to contact this.
All sides are represented. Next paragraph, Mr.
Zed Ahmad.
Z.
Ahmad.
Hanam.
Ahmad.
Hamad.
Hamad, I'm sorry. Hamad and the counsel for the
That's 1 or 5.
respondent number 5.
Right.
Upon instructions, submit that the petitioner has expired. Next, Mr. M.J. Barwar Ranade, counsel for the petitioner, pays for and is granted 2 weeks time to uh, to to verify the same. Next para. List on give a date after 2 weeks.
Vacation good.
21/6.
No problem.
Item 12 with 13.
Yes.
Lordship. Senior is on leg. Oh, give me 2 minutes.
Okay.
So the lordship, by last order, because some dispose of petition along with this case matter. Some dispose of matter tagged with this case matter. Lordship credits last order.
Let him come.
Acknowledgement, I was on legs. My lord, this matters were already is a similar matter in WPC 7070 of 2015. Last time when I placed the order, my lord had referred that because the order has not been passed, so this order needs to be modified, but otherwise the entire issue is same.
No, entire issue being same and the matter being disposed of are two different things.
Yes, ma'am. What had happened, my lord? My lord had heard all these matters together, and at the end.
I remember.
Yes, ma'am.
I don't forget so easily.
Yes, ma'am. I just wanted to remind you.
You see, that means you are trying to say, in other words, that I must be out of my mind to dispose of the writ petition and issue a direction that notice be served.
No, my lord, may I just, what had happened when my lord?
Please don't justify it. You see, a mistake of the court is a mistake of the court.
My lord.
You can't justify and make it, make a case disposed of merely because we have said so. It was an inadvertent mistake. Even in the wildest of dreams, we would not dispose of a writ petition and then say that notice on the unserved person be served. Can that happen?
May I just
And
submit?
do you subscribe to it?
No, madam, that did not happen, madam. May I just submit? Well, the entire matter was heard with the bunch. Thereafter, when the matter was heard and when the order was delivered, at
So
the.
why there was a distinction in passing an order to issue a notice?
Yes,
here?
my lord, because when the matter was heard, at that time, the learned counsel for the petitioner did not point out to the court that the notices were not being served. When the matter was heard, in a composite.
No, that's different. But can I dispose of a matter without hearing without issuance of notice on a party?
No, madam.
Therefore, the court in this matter took out this bunch.
Yes, madam.
And these two matters were segregated. There's
Madam.
no point in segregating two matters when the court in a common hearing dispose of other matters.
Absolutely, ma'am.
Correct.
Yes, ma'am.
So therefore, this two was carved out, but inadvertently, when we dictated the order, these two cases also got in.
Yes, madam.
We say that these are also disposed of. It could never be disposed of. Notice is not served. Therefore, there is an inherent error on part of it. Therefore, we issued a direction that you serve notice. But this order came to be tagged with in the other writ petitions. I say that this it covers this.
Yes.
We are passing separate orders.
Yes, separate orders. Yes.
So in separate order, we have done this in this matter. It was that, it was a record, 5454 ROV. No, 7070. No, okay. Letter below. At this time, Hussain, learned counsel for the petitioner, as well as Mr. S.P. Sharma, learned standing counsel for the APDCL. Next matter. By an order dated 14/5/2024, this court, having perused the judgment and order dated 2/5/2021, passed by this court in WPC 3327 of 2017. Specifically, paragraph 21 of the said judgment, this court had arrived at a prima facie conclusion. It was of the prima facie view that perhaps an inadvertent mistake was made in paragraph 21 of the judgment and order dated 12/5/2021, passed in WPC 3327 of 2017, only in respect of observations made in paragraph 21, wherein it is noted that separate judgments are delivered in this writ petition, i.e., WPC 3014 of 2015, as well as in a connected WPC 5454 of 2017. Full stop. Next part. It may be stated that by separate orders passed in WPC 7070 of 2015, WPC 3938 of 2017, WPC 3071 of 2017, WPC 3086 of 2017, and WPC 3327 of 2017, same inadvertent error has crept in. Next paragraph. Next paragraph. It may be stated that the that 7 writ petitions were heard analogously on 22/2/2021, and while and while 5 writ petitions were dismissed, the records of 5454 2017 and WPC 3014 of 2015 were segregated and and on 12/5/2021, the court having noticed that no order was passed in WPC 3014 of 2015, accepting due service of notice on private respondent numbers 8, 11 to 22, 26, 30, 31, 33, 35 to 38, 40 to 44, 46, 49, 50, 52 to 59, 61, 62, and 69. This court had taken note of the fact that the matter was allowed to be heard and the delivery of judgment was kept reserved. And that it was also held that the defect regarding non-service came to light only while examining the records. Next paragraph. Therefore, the court released the matter without delivering judgment. And accordingly, the and a direction was issued to the petitioners to take fresh steps within 11/6/2021 for service on the notice on the respondents referred above, by registry posting DD. Post. Next one. The learned counsel to the APTCL has submitted that on facts all the cases are on similar footing. Full stop. In this regard, the court is of the considered opinion that whether on facts all the cases are similar or not is a separate issue. But when on 12/5/2021, this court had issued a direction for service of notice on the respondents on whom notices were not served, merely because of an observation made in para 21 of the order passed in WPC 7070 of 2015. In paragraph 21 thereof, that separate judgments have been delivered in WPC 3014 of 2015 and WPC 5454 of 2017 would not be sufficient to treat the said two writ petitions as disposed of and covered by the separate judgment and orders passed in other 5 writ petitions, being WPC 7070 of 2015, WPC 2938 of 2017, WPC 3071 of 2017, WPC 3086 of 2017, and WPC 3327 of 2017. Next para. Therefore, comma, if court is inclined to observe that the reference to the separate judgments being delivered in WPC 3014 of 2015 and WPC 7070 of 2015, as stated in paragraph 22 of the said judgment, is an inadvertent error on part of the court to make that observation. Full stop. Next paragraph. Hence, comma. Having held that the reference to the said two repetitions is an inadvertent error on part of the court, comma. The court is of the opinion that it should not hesitate to admit the mistake and to recall the reference to the said two repetitions from paragraph 22 of the judgment and order passed in WPC 7070 of 2015. Next paragraph. Accordingly, the court is inclined to exercise suo motu review of the judgment and order dated 12/5/2021 passed in WPC 7070 of 2015. Insofar as the reference to separate judgment being passed in WPC 3014 of 2015 and WPC 5454 of 2017 is concerned. Stop. No other part of the order requires any correction whatsoever. And the review is limited to the striking out of the reference to these two writ petitions only. This will be common order in all. This 5 writ petitions. Yes, what about service? Mr. Hussain, in this writ petitions?
The other service is complete, my lord, and that is why the case is come up for hearing, my lord.
For hearing. So we'll hear it and we'll pass the same order. We can't give a different order. Judgment will be same.
No, my lord, the issue was not same, my lord. Issue was not same, my lord.
That.
My lord, it may fix for another date.
We are hearing it.
My lord, for hearing, my lord, after 2 weeks, my lord.
No, we are hearing it. It's 2014 matter, we are not a
My lord,
15 matter.
I am for my lord petitioner, my lord, I have time for only.
No,
because-
no. Then we recall this order, then we pass orders when you come again, prepared. We can't be, you can't play hide and seek with the court.
My lord, no, this week may be fixed, my lord, only time was.
No. You close it, you file a written argument.
My lord.
We close it, you file a written submission.
My lord,
All matters we are not adjourning.
only because my lord, as other.
No, you see, from 2021, you have the time to prepare it.
Yes, my lord,
No. Will not permit.
Then my lord,
By tomorrow morning, if you don't submit, we'll pass the same judgment. By evening,
My
we'll
lord,
be releasing it.
my lord, there is my lord, about, my lord, 60 private respondents.
It may be 6,000, we are not bothered with
My
it.
lord, so we have to,
2021 to 25, 24, you
my
have got
lord,
4 years.
my lord, then I may, my lord, argue some, my lord, the issue are.
You file your written submission by tomorrow morning.
My lord, well, it is impossible for me, my lord.
No, we are not doing it.
Then, my lord, I am ready to, then
Yes.
to do itself, my lord,
Yes, please do it.
my lord.
Three zero one four.
301.
Just a moment, let us see. Yes.
Worship may first, my lord. Advertisement, my lord.
Petition. Page 80.
Page 80. Page. Yes, my lord. Advertisement, page 76 to 80, my lord. My lord,
Who is the private respondent who got lesser marks than you and then was appointed?
my lord, in three, my lord, 3014, my lord.
Yes, 3015.
In read petition, my lord,
Yes.
3014, my lord, I have not, in this case, my lord, I have taken separate issue, my lord, eligibility of the private respondents, my lord. Here, in this petition, I will not challenge the merit list, my lord. The respondents have got lesser mark than me. Here, I got eligibility of the respondents, my lord. So, my lord, Lordship may peruse page 76 advertisement. Bottom, my lord. Category A for candidate having ITI certificates.
Yes.
my lord. Advertisement, my lord. Page 76. Category A for candidate having ITI certificate at the bottom, my lord. And qualification, ITI passed in trade of wireman, electrician from government ITI and government approved ITI only. So ITI, my lord, the ITI diploma is taken after passing of the SSLC examination, my lord.
Yes.
Here is the candidate must be less than 18 years and or more than 37 years. That is not issuing, my lord. Next, my lord, page 77, column number 2, category B, my lord. Temporary workers engaged in any power utility to work as Sahayak.
Yes.
My lord. Now, in category B, subcolumn 1, experience. The temporary workers engaged in any power utility for performing the job of the Sahayak continuously for more than 3 years.
Yes.
Next, my lord, next 3, educational qualification. HSLC passed provided that temporary workers engaged in any power utility who have rendered service for not less than minimum period of 3 years are allowed one-time relaxation for the recruitment only on educational qualification from HSLC pass to class 8 standard pass. However, they will have to submit certificate regarding their engagement for 3 years from concerned Assistant General Manager. Lordship noted this, my lord. Concerned Assistant General Manager, my lord. Assistant General Manager.
Yes.
Category A candidate passed SSLC examination and ITI passed in electrician trade. Category B candidate only passed class 8. Only condition is that he should have experience of 3 years, and that certificate is to be issued from the concerned Assistant General Manager. My lord.
Yes.
My lord, now page 79, my lord, last paragraph, my lord. And the subcolumn 8, Roman 8. The application complete in all respects should reach in the concerned circle office of the Deputy General Manager, Electrical Circuit within 30/4/2013 during office hours. Candidature of any candidate may be cancelled at any stage of application is found incomplete and any information on declaration mentioned by him found false or incorrect. This is the idea of the advertisement. Now, Lordship, may and the petitioners are all the read petitioners are under ITI passed, my lord. Some are HSLC and some are higher secondary. HSLC is the qualification along with ITI passed candidate, my lord. Now, Lordship, my lord, page 11111, my lord. Annexer, my lord.
Yes.
Here, my lord, the certificate was issued, my lord. Here the certificate issued, no memo number, nothing of the sort. Moreover, the certificate issued by the sub-divisional engineer criteria is Assistant General Manager. My lord. This is to certify that Sri Minal Chandra Chaudhary, Ramesh Chandra Chaudhary, village so and so, Dhuri, is a contractual labor working under the contractor under Gauripur Electrical Subdivision will effect from 2008 to till date. During the period, he has gathered experience in electrical line construction work so and so. So certificate was issued, my lord, subdivisional engineer against the, my lord, advertisement, my lord. My lord, next, lordship page, next page, my lord.
Are you right? You are correctly reading it?
My lord.
Are you right? You are correctly reading it, this document?
My lord, subdivisional engineer below, bono.
You're completely correctly reading it? Third time I'm asking you.
Subdivisional engineer, Gauripur Electrical Subdivision, APDCL, LR Gauripur.
Then Mr. Hussain, we cannot hear you more. If this, if you are for the third time you are saying this is correct, then we need not hear you more because it's a wastage of time. The last signature is of counter signature by Assistant General Manager.
Yes, my lord. I
So if there is a signature or counter signature.
Yes, my lord.
That's
Whether
okay.
my lord certificate issued in advertisement, there is no column there. The
No, that's
certificate
okay.
should
It's a
be issued by the.
departmental work. They ask the juniors to do it. They prepare it and then they countersign.
My lord.
If a
Yes, my lord.
certificate
Lordship
contains
may
two
be-
signatures.
Yes, my lord.
Now you see, you will find in each and every notification issued by the government that in the side, somebody will sign it. Then it is placed before the concerned officer and then he will sign it. In issue numbers, you will find that a different officer is signing it. So you see, these are merely departmental orders. And when they say that it's having a countersign, you see the reason is the reason is because this subdivision officer is signing it. It sends to the it is sent to the AGM. AGM signs it.
My lord, next page, my lord.
You
Here, my lord.
can't say that the
Yes, my
document
lord.
doesn't
So
have it.
another also, my lord, that lordship may consider. In page 112, my lord. Here, that 3 years, my lord, length is not shown, my lord. As per advertisement, respondent number 9, my lord. This is to certify that Sri Token Chano Sil so and so relates to Tulsibil in the district of Kokazar, BGAD, Assam, that he is a worker of SPPS agency, Kotimari Ansolik Welfare Society. He gathered much experience in the LTH and maintenance of electrical works along with internal house working and electrical equipments works. His performance found to be satisfactory, my lord. Here, my lord, at Ansolik Society, Welfare Society. Kotimari Ansolik Welfare Society. He worked under Kotimari Ansolik Welfare Society. And here, that 3 years experience not shown, my lord. Next page, my lord, lordship, next page 113, my lord. Here, my lord, only experience is 9 months, my lord.
Just a. Yes.
Page 113, my lord. Here, third line, my lord.
Yes.
Labor working under contractor under my supervising during July 2012 to March 2013, my lord. So experience was only 9 months, my lord.
Yes.
Next, my lord. Page 114, my lord. Will you what happened, my lord? I have two files. Another file I have left out. I have written all the page numbers. Here, this candidate, my lord, not past 8, my lord, but that must be so.
You see, it doesn't take us anywhere. Your argument doesn't take us anywhere. The reason is that you are ITI and therefore your posts are different. These are non-ITI, their posts are different. So once there are two categories A and B, and you can't infringe on the posts which are, even if there's a defect, you can't come and get yourself
No, my lord,
job.
my lord, in advertisement, my lord, same category of post, my lord. There is no distinction between A category and B category, only
There has to be different. You see, once they say that there are two categories,
only
there
for
must be-
one-time election is given them for class ITI passed by HSLC passed to class 8 passed with certificate, my lord. But the post are same, my lord. There is no category wise that some post are for ITI pass candidate and A category candidate and for post of V category candidate, that post was not, my lord. If lordship can peruse the advertisement, it will be clear, my lord. It's page 80, my lord, at first, my lord. Page 80.
See, will tell you. You see, I have taken the pain to note everything. Tejpur has 105, Kachara has 54, Badarpur 80, K and CH Electrical Division has 12, Nagaon has 49, North Lakipur has 24. So these are the posts which are mentioned in the recruitment advertisement. Correct. So there are two categories who can apply.
Advertisement, it is clear.
Yes, what is your stand, Mr. Sharma, in your affidavit? Do you say that they are post earmarked for these two categories?
No, my lord, that is one of our standard. He does not have the local standard to
No,
select.
that's different.
Yes, my lord.
But if two stream
Yes, my lord.
can join in the same CADA and you don't have a earmark difference, then maybe a graduate and a postgraduate can both come into the what you call. Let us say that for the post of grade 2.
Absolutely.
You permit 3 streams to apply: science, commerce and arts.
My lord, I absolutely understand what my lord is saying. My lord, the contention of the petitioner is relying upon the experience certificate. That has been squarely covered by the judgment of my lord 707/2015. In fact, the paragraph 20 particularly says that, however, on perusal of the documents annexed to the connected writ petition WPC 3014 of 2015, it appears that the workers engaged by such third party had obtained experience certificate which were duly countersigned by the AGM concerned. In this regard, the court is of the considered opinion the respondent number 2 to 7 is entitled to some amount of freedom in the matter of selection and appointment, as they were aware of that what is their requirement when issuing employment advertisement. And my lord, with regard to the certificate which is showing that 9 months, my lord, the category B is very particular. It says you should be a trainee under any Sahaya, under any institution, but it has to be power. And the certificate which he shows, it says under me, that under that person, under the assistant electrical division, he was there for 9 months. But because of that, my lord had given this liberty as per the 707/2015 and held that some kind of liberty should be given to the employer in collecting the experience certificate, as they have been countersigned by the assistant electrical engineer. So his entire argument is upon the legs that the experience certificate which they have produced, they have been countersigned by the assistant general manager.
That is another aspect, my lord. My lord, that is another aspect. If, my lord, advertisement shows that 3 years experience, my lord. If 9 years experience can show, my lord, that is a separate thing, my lord. Somebody, society, NGO, shopkeeper issued, and that AGM countersigned, my lord. That is separate, my lord, issue. And if, my lord, somebody not passed, my lord, class 8, my lord, if somebody is minor, my lord, then also it come, my lord. Somebody is minor, my lord. Somebody is not passed, my lord, class 8, my lord. My lord.
You are a different category. How do you jump into this?
My lord, I stated in para. 15, my lord, lordship may produce my 32 page, my writ petition, page 15. Sub.
We have seen that. That's why we are segregating. We know where we stand.
My lord, all things, my lord, that is in this writ petition, I have not challenged that private respondents secured less mark than me. Here is my submission is that they are not eligibility for apply, my lord. How can they, my lord, got more marks and selected and got appointment? Here I have stated lordship can peruse page 15. It is really clear, my lord. Lordship may consider if the countersign is considered, but somebody is, my lord, experienced more than, less than 3 years. Right. My lord, Lordship, Perus, page 165, my lord, he not passed class 8, my lord, 165 page, my lord.
It's written, she was reading in class 8
Yes,
in
8 passed
1980.
class 7, passed class 7, and he promotion for class 8.
Okay, it's a combined test.
Hello, may I just submit it?
Just a moment.
Oh, no, category.
Mr. Sharma, which is the paragraph you were referring to earlier? You just read which paragraph?
My lord, paragraph 20.
Mr. Sharma, this, what do you call this process of recruitment? Was the last date of submission advanced, postponed? Or it was the date on which the advertisement says?
My lord, it is the date on which advertisement says. There is no postponement or alteration of it.
No alteration. Then three certificates, three people have to
There's a
go.
corrigendum.
Three people then have to go.
My lord, there's a corrigendum there was that it was extended, my lord, to 31/5/2013.
Tell us where.
Yes. It was extended up to 31/5/2013.
Lordship, in 5454 writ petition, I am appearing for the private respondent. And I have submitted my affidavit in opposition in that case.
You have disclosed this.
Yes, my lord, the
Lordship,
31/5.
page
31/3 is the last date.
Yes, my lord.
Yes,
Okay.
31/5, Lordship.
31/5. Okay.
31/5/2013.
Then as per the projections made in the red petition, it boils down to three people. 11, 12, and 28. The defect in 11, 12, and 28.
My lord, with regard to 11, I think it is with the age.
Yes.
My lord, that is, can be seen for the educational qualification in the advertisement itself. It says that provided, may I read, my lord, page
Yes.
80. Provided that the temporary workers engaged in any power utility who have rendered service for not less than minimum period of 3 years are allowed one-time relaxation for this requirement only on educational qualification from HLC pass to class 8 standard passed.
This also go.
Yes, however, they will have to submit certificate regarding the engagement of 3 years from concerned assistant general manager.
Okay.
Yes, my lord, page, my lord, 11715, my lord, that experience shows 1 year, 11 months, my lord.
Well, for that, we have already passed an order earlier.
My,
We
my
can't
lord-
take a different view.
my lord. And, my lord, page, my
We
lord,
have done that exercise. We have checked the documents of this serial number 43, 58, 9, 53, 11, 12, 28, 18,
Yes.
43, 56, 23, 52, 54, 55, 56, 23, 52, 56, 66, 11, 12, 28. So this we have examined. So only there were two queries which we have put and they have successfully answered these two.
here, my lord, page 127, not pass class 8.
That he has explained, I have taken it. You have read everything.
Okay. And, now, my lord, in lordship, may, my lord, his lordship will gone through the, my lord, merit list, my lord, what they submitted, what they have submitted, my lord. Lordship may peruse page 13, my lord, page 133, my lord.
One 133, yes.
Yes, my lord. 133. And lordship may peruse the, my lord, they have submitted the merit list, my lord. Along with that. In this case, my lord, they have submitted only on the affidavit in opposition. They have submitted in affidavit opposition, my lord, in 5454, my lord. In Munir Road.
3014, they have submitted. Yeah, affidavit.
Submitted, my lord, only they have contended that I have no locus to challenge the, only that much, my lord, and others. That we are the category A candidate, we should not challenge.
This page 133 you were showing us,
Yes, my
what
lord.
is there?
Yes, my lord. Now,
133.
my lord, now, lordship may, in affidavit in opposition, lordship may take the in 5454, my lord, they have submitted in affidavit in opposition, and in this opposition, my lord, they submitted merit list, my lord.
Yes.
Our merit list was separate, but they have submitted this merit list, whatever may be, my lord. The merit list, my lord, in serial number, roll number 14, my lord, that merit list, first one, my lord, serial number 1. And
Yes.
this Sonam Bromo is the respondent number 67 in 3014, my lord. In WBC number 3014, my lord, whatever may be, my lord. There, the experience, my lord, in page number,
Serial number 1 is respondent was 67.
my lord, sorry, my lord, in page number 160, 162. 162, my lord, sorry, in repetition 3014, page number 162.
3014.
My lord, first one, lordship, my lord. Now we are going to tally in between the experience, my lord.
No.
My lord,
3014 page number?
3014, page number 162.
152.
162.
62. Yes. What is that?
Yes, my lord. I am placing it. Here, my lord, experience shows 3 years, my lord.
Yes.
My lord. Now, lordship can peruse in affidavit or opposition of 5454, page 11, my lord. And first column, roll number 400, serial number 1, Sonam Bromo, my lord.
5454 page number?
My lord, affidavit in opposition filed by the respondents.
Page number?
Page number 11, annexure 1. Not in repetition, my lord.
Yes.
Lordship may come in column number 1, 2, 3. So first column serial number, my lord. Second roll number. Third name. Fourth caste. Next, my lord, physical test in the top, my lord. Next, equipment identification, total marks 35, my lord. Next, experience, my lord. Lordship got it. In merit list.
Yes.
My lord, merit list. Experience, my lord. Marks awarded 20 marks, my lord. In top.
Yes.
Experience 20. 3 to 5 years, 10 marks. Above 5 to 8 years, 15 marks. Above 8 to 10, 17 marks. Above 10 years, 20 marks. If experience, my lord, 3 to 5 years, then he will get 10 marks. And if experience, my lord, above 5 to 8, then he will get 15 marks. And if experience 8 to 10 years, then he will get 17 marks. And above 10 years, he will get 20 marks. Now, lordship can peruse page 162 of WBC number 3014. Here, experience is shows 3 years. So, my lord, he should have been awarded 10 marks, but in list, my lord, he was awarded 20 marks. If lordship can peruse these documents as a genuine by the concerned authority, then also, my lord, what he should get, my lord, only his 10 marks, but here awarded 20 marks.
Is respondent number 60?
It is the respondent number, my lord, 67. No, it's a long time she has been working. Sometimes even she has been working for the years.
Okay, that's all.
My lord. Yes, my lord. Next, my lord. My lord, next page 133. Experience certificate.
Just tell us how much is it.
My lord.
Just tell us. I won't shift it to the document. Just tell us how much is page 133.
My lord, page 133, my lord, experience 4 years, 8 months. That should be calculated 3 to 5 years.
Is respondent number?
Respondent number, my lord, 38. Mark should be, my lord, 10. Because his experience is 4 years, 8 months. They are awarded 15 marks.
You just write this page number and the respondent number.
My
The
lord,
court master and give it.
My lord, may I just submit in this to
Next,
document?
my
Not
lord.
bad.
Next, my lord.
No, Mr. Hussain doesn't take me anywhere.
My lord.
The by this time you should understand. There's a saying that you should know court more than you know your brief. There's a saying in law,
My
in
lord.
legal studies, that you must know court more than your brief. This applies to this court also. Correct. You've taken us to page number 162. You have taken us to page 133.
Yeah, my lord.
You have referred to page
On the thing itself,
67.
my lord.
Just
Sorry.
hear me. You're taking us to respond number 67. You're taking us to respond number 38. But incidentally, your pleadings is not there.
My
You
lord.
don't plead what you're arguing.
My lord. I
So
don't-
you have made me read this paragraph 15 3 times till now.
My lord, I am sorry, my lord. What happened, my lord?
No, no.
I
Sorry doesn't
actually
take us
tell
anywhere.
it from my lord serial number and what experience I have some, and that
No,
is why I have some
that is okay.
confusion.
But I told you,
My
you
lord,
should know the code more than you know the law.
yes, my lord. My lord.
The fact is that you have repeated this twice and 3 times I have read this paragraph 15. All these subparagraphs 8 to 10, 1 to 10, doesn't take me anywhere. Because if that's not the pleading, they won't respond to it. And if they don't respond from 2015 till 2024, we are not going to touch this, touch this on the touchstone of this discrepancy. This is
My-
not even pleaded.
My lord, if lordship, my lord, allows my lord to this, my lord, what lordship decided
No, no, no.
indicate that is up to lordship, my lord.
No, no.
I will, my lord, submit a written argument from all the, my lord, pages including there.
No, no, with that nature of your submission, your argument will take us nowhere. You are beyond the point. You are besides the point. You make one submission which is based on the factual metrics, then we understand, but your submission doesn't take us anywhere.
I am telling from my lord merit list, and that is why page runs when my lord, suppose my lord, merit list, in merit list serial 1, that page I have annexed in 162. Suppose my lord, serial number 2, through the by that I have followed serial number my lord, that merit list, and that is why my lord, that is sometimes it goes to the 113 something.
I'm not accusing you of anything.
And
But I'm telling you, when you are making an argument, I simultaneously read the paragraphs, I simultaneously compare it with your affidavit file. It doesn't take us anywhere.
lordship may, lord, I will submit.
Mr. Hussain, also please try to remember, we are hearing matters from 10:30 till 4:30. Correct.
My lord,
Hearing is not so easy.
that is why, my lord, I have, at the first instance, I have submitted before your lordship, my lord, I may be allowed some time. So, my lord,
In 2015 matter, we are not adjourning. At this time, Hussain, counsel for the petition, as well as Mr. S.P. Sharma and counsel for the APDCL, and Mrs. R. Chaudhary and counsel for the private respondents.
In this,
Give
I have.
the number.
No, lordship, I have submitted my Wakalatnama, but there are some defects maybe there, so they have returned the Wakalatnama in 3014. 5454 I have submitted and.
Just write it down for whom we are referring in this matter.
Power department, respond number 1.
Yes, sir. For the respondent of power number one, Mr. I forgot the names.
CS other.
CS is that. I'm sorry. I'm growing old. I'm going to say confidence in myself. This comparative on the this page numbers, if you want to give with regard to the no argumentative argumentative submissions. Only if you want to refer to the documents, the what do you call this
page number,
and the respondent number.
And
Just
what-
give it in the chat and give it to the court
what
master
is
with
the-
a copy to Mr. Sharma.
and what is the informative, my lord?
Don't give any argumentative.
Not my lord argument, what is the informative, suppose not passed,
No.
that is my lord, not passed, but not
Give it.
like this, not.
Oh, it will be given to me. I didn't get the last part, man. But I did not catch the last part. I'm so sorry.
The chart he will give it to the papers which you will rely. He give a copy to you and then copy to the court master.
My lord.
In my lord. That's, that chart I have to type out, my lord, by serially, so.
Give it tomorrow. You can give it in a handwriting form, doesn't matter to. You write it down and give it to me.
Obliged.
Or give it tomorrow, take a day to tomorrow, give it day after tomorrow.
I'll
The copy to Mr. Sharma.